Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Validating commentary on the case.
Good morning, welcome to Court of Public Opinion. I'm the Recovery Addict, got my nice hot cup of steaming hot chocolate, ready to begin. What was that zoom in? On the raid? Just having a little cup of get you going in the morning. Great. Oh, and it's good. It's good. Oh. I have to admit, it is not Stevens. I don't know why. My wife has hidden all the Stevens gourmet chocolate. Hot chocolate. I'm drinking Swiss Miss. It's still better than not drinking hot chocolate, but it's not Stevens, it's Swiss Miss. Oh, good morning. No, the zoom in on your computer. Oh, the zoom in on my computer. That zoom in. Now I know what you're talking about. Hang on. Let me see if I can show you. I was just playing with something I might implement into my live stream, but I was just doing it live, sorry. So it was what it was. It was this right here. If you want to see, looks like that. Like that. I just filmed it this morning. It was cool. It was cool. I'm a Monster Energy addict, just Becca. Hey, guess what? Hang on. Schmoopy. Congratulations on being first in chat today. Super excited about this. Is this your first time, Schmoopy? It's your first time under this name? Because you guys change your names so often. Is the statue CGI? No, the statue is real. I went to the post office. I had two Lady Justice statues. Bail Jumper, Teresa Super, thank you very much. I got a, I don't know what we call it. It's a pocket size and a desk size. I got 2 amazing Lady Justice statues. Let me see if I can hold this one up. This one is... It is absolutely gorgeous. It's functioning scales. I was thinking I was going to put Pickles on one side and politics on the other and just see which one actually does weigh more. Thank you. Just absolutely beautiful. That goes on the shelf right here. And then I got a bigger version of the same thing in bronze. This is heavy. Just so you know. This is... hang on, I'm tilted her scales funny. Right there. Yeah, Mrs. R.A.'s bookshelf is getting full. This cannot fit on the bookshelf. And I also can't put it on my desk. I was looking for places to put it over next to the TV. Everywhere I put it, it was behind like the camera or behind the microphone or in front of the screen. I am so super excited about these two. Wow. You guys, I talked about how gorgeous the statue was. Just like not gorgeous. Gorgeous is the wrong word when you're describing a woman other than your wife. How regal, I guess. I don't know. It was a beautiful statue that we saw in court the other day behind the judge. And she had like the 3/4 life-size version, which is like just nuts. Crazy. But, you need to put one on the mantle. I'm going to try to figure out what to do, how to rearrange everything, what tech I have to throw away to make this work. But I'm super excited. I have to go back though. Schmoopy, I missed it. Is this your first win? Is this your first time you've been first in chat? Congratulations. Either way, being first in chat comes with a punishment. I know. Sorry. You thought you won, but you're getting punished. We're going to send it to you to internet ownership, and you're responsible for everything IP-related worldwide. Just for the record, I'm going to spell this out. It pains me to do so. This includes setting up all the Starlink devices in Western North Carolina. So you might get a few calls, but luckily Elon is there to help you out. He said he's going to make them all work without anyone paying for service at all. So hopefully you got a hand there from Elon. He'll be there to sort of like your right-hand man when it comes to taking care of the internet. So congratulations. That is wonderful and wonderful win. I got to put one on the mantle. I have to. Yes. The mantle's the only place that's tall enough to put it. But the other one that goes on the bookshelf, it's going to go right there where the screaming goat normally goes. So the goat and the Lady Justice, I think, are a matched pair. Because on one side, we're like, yes, there's justice. On the other side, we're like, ah! So I'm super excited. I'm super excited about this. Thank you for your generous gifts. These are beautiful and amazing. MCAT just gifted 5 memberships. Good morning, MCAT. Good morning to you as well. Welcome. Good to have you here. Thank you very much for your generosity. I want to know the breaking news. Ashley, I've been working, I went to bed after midnight last night. After first sticking my phone in my pocket and pocket tweeting. I don't know how it worked. Normally my phone does absolutely nothing in my pocket, but I pocket tweeted something like I.JD space T or something. I don't know. It meant nothing to me. But here's this channel called Recovery Addict on YouTube looking fully like I'm drunk tweeting. I kid you not. And everyone's like, hey, you had a few? And so I'm like, I can't delete the tweet to be like, oh no, hide the evidence, right? I didn't have a few. It was just in my pocket. And so I'm like, well, I need to explain. So I tweeted again. I said, I don't know how that happened in my tweet. And I hit send. And then I looked at the tweet and I realized I had spelled things wrong. I'm like, this is only making it worse. It's making it worse. When you misspell your explanation for why it wasn't actually a drunk tweet. I butt dialed Twitter. I pulled a Canton. I was thinking, how is this possible? But I did. I not only opened Twitter, I formulated a tweet and I posted it, without ever knowing it. So I have to give those guys up in Canton a little more credence when they say, yeah, we butt dialed back and forth. And, I answered, he called back, I answered, and it was all butt dials. Maybe it's possible. Maybe it's possible. Oh my goodness. I'm the Recovery Albert, says Nosy Rosie. That is so bad. That is so bad. I ended up in my attempt to fix it. Here's what happens. So my original post, IJB by T was what it said. So if you guys can decode that, please let me know. I don't know what it means. Then I said, I wish I knew how that happened because I spelled it wrong. And I finally said, I guess misspelling my reaction to my pocket/butt tweet does little to quell the prevailing rumor. And so just so you know, that was a pocket tweet. I don't drink. And now the first tweet is going viral. So people aren't seeing the explanations. They're seeing the first one. But I can't really delete it because everyone's like, mm-hmm. Yeah, anyway, so you were explaining the breaking news. You want to know the breaking news, says Ashley. I've been working till late at night fixing up my channel because there are some courts in this country that are not really up to date on how media works and how there is a new media that is not your grandfather's newspaper, your uncle's radio station, or big corporate's TV channel. There is other media out there, and the courts are slowly coming around. Some recognize us immediately. New Hampshire, they list me right up there with CNN. I'm like, you can go on the New Hampshire's website and you'll find my channel listed as media with CNN. That's great, New Hampshire. Florida, not so much. and specifically, we're still fighting an issue with Sarah Boone's court, which is happening in a week. And one of the things they needed was certain documentation. Let's see, I had to upload what? Five different documents, as well as contact information for editors and everything else. They are just jumping through hoops all over the place. So I'm still trying to sort this out with them. So I was doing and part of that change, but to make it more clear to them what we do, was changing the banner on the Recovery Addict channel to indicate that I am wholly owned and operated by the company Top Mark Media. That's my company. So I, as Top Mark Media, operate Recovery Addict. If there's any confusion about that, let me make that perfectly clear. So that was the update. That's why the banner looks a little bit different. And we have a couple editors. Red Pen, I might take you up on this. We have no birthdays today. We have no birthdays. That is crazy. Because
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. We're halfway through the work week. Dancers need to dance. So as Red Pen says, hold your ears. We made it halfway. Next week is Sarah Boone. We've got a huge case starting then. Oh my goodness. That sounds like a headache. It is a headache. Every time the paperwork is absolutely nuts, and it's getting worse. It seems like every time you make like 2 steps forward, there's another court that makes you jump through more hoops and do a little dance. And pretty soon you're singing "I'm a Little Teapot" to please the judge so you can get into courtroom, and it's not a good thing. Let's see. Culperistic says, I thought I was here for independent journalism, but turns out you've been in the pocket of Top Mark Media this whole time. I've been fooled. Yeah, write to their management and complain. Culperistic. I think you'll find a sympathetic ear on that one. We can sing to those who have birthdays who we're unaware of. Give it time. I think we're going to have a birthday come in. Give it just a minute. I see this. Judge Boyd's recused and reprimanded. She's going down. Judges get reprimanded all the time. Do you know what takes a judge down? The people. The people take the judge down. Unless the Supreme Court steps in and says this is so bad, we're taking some action here. As long as you please the people, when you go up for re-election, which judges do, they go up for re-election. It's very hard to unseat a judge, especially one that is well liked. So she has to really irritate a lot of people. But we'll see. It could happen. I mean, stranger things have happened. I'm not defending her. I don't know the facts of the full facts of the case. I've just heard little bits around the fringes. Let's see. Please turn on seats. I was so busy getting the. Intro with the little zoom in running that I forgot to turn on the seats. Everyone is standing around. I just thought it was because you weren't sure if you wanted to stay or not, but no, it's because I didn't have any seats available. All right, seats are available. Katia, do you have a name we can sing to? Or let's see, Soraya. Is it Soraya? Katia, is it Soraya? Give me the pronunciation spelled out in crayon. So a little child could read it, and I'll do my best to pronounce it right. As everyone takes a seat. This is effectively the same thing as everyone jumping in the elevator at the same time. When everyone just sits down at once, the earth moves. Soraya says, that's good enough. Soraya works. All right, we get to sing to Soraya today. Let me put your name back on the screen. Soraya, happy birthday. There we go. We're not singing to Sharon, although we could. It's not Sharon's birthday. Let's see. I think that's. I think I got it right. Just making sure there's not another pronunciation. Not on screen. On screen now. All right. Join with me, if you will. Sing happy birthday to to Soraya, Katia's sister. And warm up with me, if you will. La 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 la. Katia says, I need to clip this for my sister. She needs to watch it live. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Soraya. Happy birthday to you. Soraya, today's your special day. Out of all the days of the year, this one is yours. And as such, you get some special privileges. One of them is free pancakes at many different establishments. Denny's, IHOP, McDonald's. I went there. I'm sorry. Some people like McDonald's pancakes, and they think, that flapjack stack changes the world. But wherever you choose to get your pancakes, make sure you get them today and make sure they're free because it is your birthday. Happy birthday. I realize there are a million places you could be and a million people you could be with, but you've chosen to, after the fact, be here with us. We won't hold that against you, so hopefully make your day a little special hearing this. Your sister is amazing, by the way. Katia is just a joy to have on the channel. It would not be the same here without her. As you probably know, she's amazing. So thank you very much. There's no IHOP in Portugal. Well, then Katia gets to make you pancakes. Lucky, your sister is going to make you breakfast in bed. How about that? All right, Katia, happy birthday. Have a wonderful birthday. Thank you to all the dancers who danced. Thanks to all you who sang around the world, blending your voices with those of your neighbors and celebrating Katia's sister, Soraya's birthday. Wonderful way to start the day. I'm glad you had a birthday because all we could do other than that is just sit around and drink our raid in the morning and yell hump day, which is a good start, but birthdays are better. Katia says, this is my present for her. That is awesome. Katia, honestly, it's so good to have you here. It's so good that you shared your sister's birthday with us so that we could share it with her like that, if that works. Ooh, drum solo's coming up. That was our cue. Everyone get your air drum sticks ready. Sit down properly on your drum throne. Let's get this big finish here. Dancers are doing the high kicks. Look great. Boom, boom, boom. Just like that. Thank you. Happy birthday. Soraya, that's awesome that you get to have a birthday today. Somebody needs to, and today's your day. All right, where are we at? We're going to go to Judge Simpson first thing this morning. The next big case we have is Sarah Boone. We might pop in on some little ones that are happening. Young Thug is about to pop off. We might have to follow that, especially if it explodes and ends in the fireworks show, which I expect it to end in. And let's see. Wait. You guys don't go anywhere. Hold still. I just remembered something. After 1 hour and 34 minutes of deliberation, the jury in Thurston, Washington returns a verdict. A verdict in the weed versus speed, or the weed and speed trial. Yes, we thought they might be stumped. We thought they might be hung, but it meant all 6 people managed to reach a conclusion. And then it got spicy. All right, let me see if I can get this to play properly. Let's see. Save that as Thurston. Open it back up. I need this window to work so you guys can see what I'm talking about. Missed the trial as well. It was a one-day trial. It was a one-day trial. The defendant was accused of token up and putting the pedal down, and the two don't mix in just about anywhere. Let's see, where's Thurston? Skip this. Why am I not getting my workspace? Boom. Okay, we got it ready. All right, so this is court. This is us. We're going to jump back to... We're going to jump back to the beginning. where it all started. No, not really. Just the beginning of the verdict. Make some room here. All right, here we go. Let's rewind. Here we go. All right, we're all good. So we have a verdict. Let's jump in now on Thurston, Washington, while we listen in as the jury returns the verdict. This just happened yesterday afternoon. Hour and 34 minutes was my time of deliberation. But let's give it a go. That was really loud, wasn't it? That was really, really loud. Sorry about that. That's what happens when I get hot chocolate in the morning. Please tell me we have audio. There we go. Okay. That would have been bad.
Thank you very much. Everyone can have a seat, please. And so the presiding juror, I've been handed a verdict form on 2 different forms, and this is signed and dated today. Is that your accurate verdict? Okay, thank you. So just going to announce the verdict then. On
no pomp and circumstance. Just
count number 1. The verdict is we, the jury, find the defendant, Edward David Gondo, guilty of the crime of driving under the influence as charged in count 1. And then on count 2, we, the jury, find the defendant, Edward David Gondo, guilty of the crime of driving while license suspended or revoked in the 3rd degree as charged in count 2. So thank you, jurors. Do you need a polling or anything?
It's not over. Now the spice starts.
Okay,
That's
thank you.
necessary.
Okay, thank you. So now that the verdict has been entered, your job as jurors is done. The court wants to once again thank you for your service, for your patience, and for your careful consideration of the case. I know it's not easy to do this and it takes time out of your day, but it is a very important and valuable service to our community. So thank you very much. And with that, you can grab your things and you're excused, and the court clerk will return the property we have of yours.
Don't forget your eggs.
Right. You leave your notebooks in the jury room. But thank you very much for your time. Thank you. Everyone can have a seat. So, defense, you had mentioned you may have a motion at this stage. Did you have a motion?
Well, I believe it was determinant on what counsel will be asking for as a requirement of sentencing. We do not believe that a prior that was committed in Pierce County counts as a prior alcohol-related offense or drug-related offense. And I think that would be the argument.
Oh, I see. So
yeah, so this, in my view, is the first in time, and I don't believe I don't know of counsel. I'm not going to represent what they think, but that
Right.
was one of the we haven't done a sentencing memo or anything of that nature.
If I may clear this up, Your Honor, the state's not asking the court to consider it as a prior that would make mandatory minimums different than a first and 7. The state's asking it to consider it in its evaluation of what the defendant's sentence should be.
Okay, I understand. So in terms of mandatory minimums, are both parties in agreement that there is no prior history of DUIs?
That is correct, Your Honor.
Counsel?
And that is correct, Your Honor.
Okay, so then my understanding of the mandatory minimums, and you guys can correct me if I'm wrong, is it's 24 hours consecutive jail time, mandatory minimum, up to a maximum of 364 days in jail.
Correct, Your Honor.
And then the fine, is our minimum fine
It's roughly $1,300. I'd have to look at the exact number, but that's a ballpark.
Okay.
It's a maximum of $5,000, a mandatory minimum of $990.50. However, our courts don't usually impose that significant a fine. So just for the record, courts typically impose a conviction fee, which is $43, and perhaps a probationary fee.
I don't know if I'd necessarily agree with that, but it's a mandatory minimum by statute. So the court thinks it's obligated to impose it.
Okay.
It hasn't been imposed on many cases, and I believe it is at the court's discretion, because I do DUIs all the time and people don't always get the full fine. That's just.
When she says she does DUIs
so before we get to that
time,
argument,
oh, never mind.
I have my court clerk here for another 8 minutes. Do you have extensive sentencing arguments, or can we
set your timer? 8 minutes.
Wrap this up in 8 minutes.
I want to have it done today because the state is asking that he report to the jail tonight.
Okay.
The state has significant public safety concerns. We can't complete it in 8 minutes.
Why do they have significant
I don't think
public
so, Your
safety
Honor.
concerns?
The state's got a toxicology report from the Pierce County case, a PC statement from the Pierce County case, judgment and sentence, the statement of plea on guilty, all related to this Pierce County case that we're wishing to introduce. The short version is, Your Honor, shortly after he alleged to have committed this offense, and so now convicted of this offense. So shortly after he committed this offense, the defendant in Pierce County was again operating a motor vehicle while intoxicated on marijuana. His blood showed 10 nanograms per milliliter. In that case, he was speeding, and for want of a more distinct way of putting it, he T-boned another car, killing an individual. He ultimately pled guilty to disregard for the safety of others, but he was in fact intoxicated on marijuana at the time of that incident.
5 nanograms or milligrams, whatever
believes
less.
that well above the mandatory minimums is appropriate given the defendant. I think it was just 2 months. I have to double check the dates again, but I think it was 2 months after this DUI, he committed that vehicular homicide.
And was convicted of vehicular homicide?
Yes, Your Honor.
Okay, thank you.
Now it starts to make sense.
So at this point, it sounds like we have a motion to remand, essentially, that the state is making. And
okay, let me pause this for just a second. What the prosecutor is saying. Remember, this happened like years ago. For some reason, this case is like really, really old. Years ago, this offense occurred. He was speeding. He was high on marijuana. He had 15, was it nanograms? I don't know what it is. Is it mg or ng? He had 15 in his system of marijuana, and he got busted speeding. Before this case went to trial, which just happened yesterday, and after he got busted speeding, he was in another county doing the same thing with 10 nanograms or milligrams of marijuana in his system. And in that case, he T-boned another car and killed one of the occupants. And that went to court. He was either pled guilty or found guilty, and he served his time before this case went forward, which might explain why this case did not go forward in a quick manner.
We need to meet back up again fairly quickly to have a sentencing hearing. What is the defense response to a motion to remand tonight and then have a fairly quick turnaround for a sentencing hearing?
Well, I would object to anything but the mandatory minimums. Mr. Gondo already resolved the other matter. He did plead guilty. He was sent to prison. His sentence, I believe, I didn't bring my paperwork with me, was 21 to 24 months. He had 115 days of electrical monitoring. During the interim portion, when all of this was going on, he was under monitoring in Pierce County by their probation department. He was also under monitoring by our probation department. He was getting random UAs. He was on electrical monitoring. I don't have the number of how many days he spent on that. He was released on bond here. To my knowledge, and like I said, I don't have my paperwork pulled up. He violated in that he was only reporting to Pierce County. He was confused that he had to report to both places. He had to check into Thurston County Jail, which he did, but he forgot his ID. So he has already served a day. And that was a significant amount of time ago. Mr. Thompson is indicating that he's danger to the community. He served a sentence, Your Honor. That is our justice system. He resolved that issue. He pled guilty. He resolved that with Pierce County. He shouldn't have to pay again for something that he has already resolved. The facts and circumstances of that event, to my knowledge, the reason I believe, and that's just off the top of my head, is that, and not that I'm condoning or in any way dismissing the fact that there is an individual who died as a result of that. However, Mr. Gondo did serve a prison sentence. He did get a substance use evaluation. He did have an alcohol and drug information school. Those are filed with the Department of Licensing. He wasn't able to get copies of those because he was in custody at the time. He has, I believe, a now 8-year-old daughter who he co-parents. I believe his mother assists him with the care of the child. He is working during the period of incarceration for his other offense in Pierce. He did lose full-time employment. He is once again employed. He's working and trying to punish him twice for what happened in another jurisdiction. I understand to a point, but he's here about this issue. He was found guilty. He should be sentenced to the mandatory minimums. This one does not count as a prior. There was marijuana in his system, 10 nanograms. However, that is not the way that case was charged. I believe there was some indication that the individual involved, not to place blame on that person, had turned in front of his vehicle. That's all that I recall. And like I said, without my paperwork in front of me, I don't want to misspeak in front of the court.
I would agree with that fact, that there was indication that she did pull out across the state's highway. The mitigator to that element, though, was the defendant's excessive speed. Yeah. Which is evident. And the reason why the state's asking for remand is the close nature of the facts in this case and that case, and the end result of that case do highlight the defendant's direct danger to the public. I appreciate that it appears his parents have been transporting him here to court. It doesn't negate the fact that the defendant is an ongoing danger to the public.
And Your Honor, there have been no subsequent. He has a driving with license suspended, second degree. That was from June 1st of 2022 that was dismissed. That was the speeding ticket that tracked that was found committed, a failure to renew, and no operator's insurance. Those were on May 14th of 2021, but no other, and I have to look at his felony history, but no other charges subsequent to those. And I would ask that the court take that into consideration as well. And that's just a brief.
All right. So I think I understand the circumstance. Actually, I think I understand just about everything for sentencing. If the prosecution's okay with that, what kind of sentence is the prosecution looking for?
State's asking for 180 days in custody, Your Honor. The defendant's total lack of remorse and it kind of just self-awareness of the danger he poses. The trooper today on the stand did allude to defendant's behavior and calling into question her competency. The court's aware of the defendant's level of intoxication in this particular case. The blood results are in. And for him, while after being arrested on this matter, then proceeds within 2 months to continue to drive, continue to use marijuana when both are forbidden for him. And the results of that definitely show his lack of remorse and lack of self-awareness. And while I appreciate that he may have done treatment while he was in custody in the Department of Corrections, simple fact is the defendant should not be given mandatory minimums. Mandatory minimums on a DUI, on DUI first or third, really should be reserved for those who take responsibility for their conduct and don't have subsequent offenses. And while I recognize that mandatory minimums go up when a person is found guilty or pleads to a particular style, and I can't speak to as why the county of Pierce agreed to amend from DUI vehicular homicide to vehicular homicide disregard safety of others. It doesn't change the facts of that case. How they resolve their case is on them. But the facts in the probable cause statement, the toxicology reports don't change. That 2 months after committing this DUI, the defendant disregarded this court's orders to refrain from substance use, refrain from driving, and refrain from driving intoxicated.
Okay. So.
And if I may, Your Honor.
Yeah.
That
really
was
quickly.
That was also 3.5 years ago. Mr. Gondo has gone to prison. If someone can resolve a matter in another jurisdiction, pay the price, which is what our justice system demands, that he resolve that with a guilty plea. Everyone has a right to go to trial. He had a right to go to trial. He thought there were some issues, as did we. And asking him now to go back and have to pay another penalty for a crime that he already resolved based on the fact that this one occurred within that time frame, when it's been 3.5 years, Your Honor.
Right.
We're asking for an additional sentence based on something that was resolved in another jurisdiction. We don't have all the facts or the reasons why it was resolved in that way. I only know what I read in the sentencing document and what my client has relayed to me personally.
And I'm sorry, Your Honor, maybe I'm not making myself clear. I'm not asking the court to punish him for what happened in Pierce County.
No,
I'm articulating that case is the perfect highlight of why the defendant should be held accountable and should not be sentenced to the mandatory minimums in this case. It shows a disregard for the dangers that his conduct in this case posed.
I understand. I understand the arguments. Unfortunately, I'm not going to have time to do a full sentencing today. I've got to let my clerk go. But I also would say that based on everything we've just talked about, I don't think mandatory minimums are appropriate in this case. And there is a public safety risk issue here. There were multiple warnings along the way in the defendant's criminal history where the defendant could have flipped a switch and changed his behavior and didn't. So I agree with the prosecution that remand is appropriate here because I wouldn't be imposing the mandatory minimums at sentencing. So I'm going to set a sentencing hearing for October 7th, this Monday at 9 a.m. where I'll come up with the final number at sentencing, and you can have an opportunity to look into that case that if you need to give me any mitigating facts you need to as far as sentencing goes. But between here and Monday would be at least the bare minimum. So it doesn't cause the defendant any prejudice to be remanded between now and a sentencing hearing on October 7th at 9 a.m.
And just for the court's information, I will have to have substitute counsel because I won't be here on Monday.
Okay. If Ms. Capone can be here, that would be fine. She did a great job today at trial.
Yeah,
so.
she did.
That would be no problem. So we'll set it for October 7th, 9 a.m. and the defendant will be remanded to the jail in the meantime. And are there any questions?
I would just ask the court, based off him being transported by his parents, I would have no objection to him basically being allowed to turn himself in. That allows him to make some arrangements between now and say 8 p.m. tonight to arrange, childcare if he needs to, but it gives him a couple hours to adjust those things.
Okay, that would be fine.
And with respect, it's almost 5 and he lives in Pierce County. Do you drive that way? I mean, I just don't want anything.
I guess the state was articulating that the state didn't expect the defendant to return to Pierce County.
No, I wouldn't expect that either. So,
No,
but
make
if
a
you
few
need
phone
a
calls.
couple of hours to get on the phone and arrange something,
That would be appreciated.
that would be fine. So we'll follow the prosecution's suggestion and order that the remand happen by 8 p.m. that he report to the jail initial part of a sentence, and we'll do a final sentencing hearing on Monday, October 7th at 9 a.m. in this courtroom.
Thank you, Your Honor.
All right, thank you.
And Your Honor, I believe in order for him to go to the jail, correct me if I'm wrong. Sorry, I'm not trying to.
I'm sorry. Okay.
He has to present that to the jail or they
Yes.
turn him
Yep,
away.
will do. I'll get that done right now.
He needs his ID, or they'll turn him away. So the judge takes care of business just for a minute as he's writes the order. It gets quiet for a little bit, and then
sorry, moving into where? Okay.
a remand letter. It's like a letter of recommendation, only it's not a good one. This is not the one you put on your cover sheet of your CV. Without an ID, you could just pay someone to do your time for you. So they are putting him in jail. They've asked for the maximum. I heard the maximum penalty they can get for this law in Washington, in Thurston County, is 180 days. Now, people are out there saying, hey, he killed somebody, he drove high and he killed somebody. That was a different crime. He was tried. Well, he was charged. He pled guilty, and he was sentenced to 21 to 24 months in that case. So that crime, you can't punish him for that crime again. But they're at the sentencing here, they are taking into the bigger picture, just like you would somebody's prior criminal conviction, to say, hey, this isn't the first offense. We're going to be a little more strict on you at his sentencing. So they're not going to go with the minimum, but the most I think the judge can do is like 180 to 364 days, max 364, so less than a year. The state hit this one out of the park. I think they did. They're getting a heavier than minimum sentence. They got full convictions on all the charges, and he's getting remanded into custody today. Well, yesterday. So looks like a strip mall courtroom. It sort of does. This is one of my favorite courts, though. I mean, I love courtrooms that have, like amazing wood architecture and everything else, like Heavenly Wood down there in what is that, Tennessee.
Okay. With that, thank you everyone for your patience, and the court is adjourned.
This court is adjourned. There we go. All right, so that ends. There we go. That ends what happened there. I'm pretty sure he turned himself in. He was just basically not leaving. His mom was there and back. I think that was the lady who was there. It's a pop-up courtroom. They should have one in like one of those semi-trucks. I saw I think it was a TikTok the other day, where in China there's a service for like when you have a wedding or something like that. Instead of renting a venue, the venue comes to you. It's one of those big long semi-trucks that just unfolds into a massive ballroom. Like the sides go out and the doors, everything stands up, and it's just like this massive ballroom. They should have one of those that's just court. Like the judge, and it unfolds, there's the courtroom, the benches pop up, and it's like, court is now in session. That'd be funny. Pulls up on the side of the road right after you get your ticket. It's like, and just walk back 2 more cars to go to court. My husband called the Dedham court when the Karen Reed trial was going on to tell them they were ruining the wood with all the tape, says Ashley. Oh, man. Your husband's a bit of a woodworker. Yes, the tape is... there are some special tapes to use. And even among the special tape, even if you're using gaff tape, which I'd say is the right tape to use for that, because it doesn't like permanently bond like on a molecular level like duct tape and some of the other things. Some brands are better than others. I bought a bad roll the last time I got a bad roll, and it like peels to itself. It just shreds itself. And for $40 a roll of tape, it's supposed to be better than that. But in China, they have a mobile death row. They've got the whole thing will come to you. Erica, you know the video I'm talking about. You saw it. Only by Tessa. I should get a good brand. I need to find a good brand. Send me a link if you got a good brand for gaff tape that we can watch. All right, we're going to jump over to what happened in Judge Simpson's court just moments ago. I don't know if it was as spicy as it, because I had the audio off. I'm sorry, that was... Let's see. I don't know where my mouse went. Which mouse is... Oh, this is the right mouse. There we go. Simpson. All right. We'll keep that. It's expensive tape. It is. It's expensive tape, but oh my goodness, it's not very appealing. I see what you did there. Say my name. That was good. Denise says, just looked. He did check himself into the jail, unlike Mr. Frog, who did not.
Trish did. You should just have to start with them. So this is very helpful. Okay. And I would recommend you okay. So this person is going to add someone to the record. And
Gaffer's tape is worth its weight in gold. You can never have enough.
County of Washington, State of Michigan is now in session. All those having business before the court are on
Look at Alyssa. Look at Alyssa. She's doing it right.
You may be seated.
She's on Zoom. She stood up when the judge said all rise.
Start out with the waiver.
Yes, Your Honor. Good morning, Ashley Lonnie for the people. Your Honor, at this time, people would waive any conflict between this honorable court and the Office of the Public Defender. The people do not believe any such conflict exists, but make the waiver for the avoidance of any doubt.
Good morning, Assistant Public Defender Lauren Perning. The Public Defender's Office likewise does not believe a conflict exists, but if one does, we also waive.
And the court, for its part, also does not believe there's a conflict either with Michigan court rules or the case is decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case of the people versus John Woolridge.
I don't know what Alyssa did, but she should get her sentence reduced.
For the people.
Just for that show of respect.
I asked her nicely not to tell you you're out. Joseph Hall.
Tell me at all.
Joseph Hall, appearing forward on behalf of Mr. Woolridge, who stands to my right. Mr. Woolridge, if you could state your name, please.
Thank you. And I start with him.
Downhill from here, Judge.
Yeah, I know. No, I don't know I can go any lower. But go ahead.
Your Honor, I believe we've worked out a full and fair resolution to this matter.
Okay.
Oh, well, she's.
Your Honor, we have, I believe that the agreement we come to, the defendant's going to entering a plea to an added count to allowing an ineligible person to operate. I'm trying to find the fact code.
I've got to see what Alyssa did.
257326.
Yes, Your Honor.
Thank you, Judge.
She's dressed perfectly appropriately for court. She's sitting still. She's paying attention. She stood up when the judge called people to order. I believe he has in this case. Even though she's on Zoom.
Another one.
She's not smoking or, having breakfast or
John, we're gonna just
having a chat with the friends.
Real quick. Sure. These are the rights we've gone over before.
I'm invested now. We're stuck here until Alyssa's case gets called.
Put your name there.
No ceiling fan. Minus 1 point.
Nope, it's 10-2.
She's not perfectly centered in frame, but she's in the frame. We can see her whole face.
Thank you. Appreciate you.
She must have been in a Zoom court.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
John Thomas Woolridge.
All right.
Sir, it is this court's understanding that you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. Do you understand that, sir?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
No, Ricky.
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No,
She
sir,
covers her mouth.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, sir, Your Honor.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On February 28, 2024, at the location of westbound I-94 near South State Street, Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
Yes, sir, Your Honor.
Did you allow someone who was otherwise ineligible to operate that motor vehicle?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Mr. Hall, anything you or your client want to say before I impose sentence?
Your Honor, I think the only thing relevant to know is that Mr. Woolridge has also hired our firm for full license restoration. He's done all of the things to file for a hearing appropriately. We await that hearing date and look forward to getting him back on the road lawfully so we don't end up back in front of Your Honor again.
All right. Anything you want to say, sir?
No, sir, Your Honor.
Fines and costs of $250. I'll suspend 90 days in jail. When do you think you can get that paid?
Give me 2 weeks, Your Honor.
You'll be able to do it in 2 weeks, you think?
Yes, sir.
Get it paid by October 31st. I'll give it to the end of the month. Get it done.
Thank you so much, Judge.
Thank you.
She said
Good
her
to see you,
phone.
Judge.
It's
Yes,
it's
good
not
seeing you,
shaking.
Mr. Hall.
This is good. Alyssa is our
Court
is our
does call
role
the case.
model
People versus Thomas
in
Hornberger.
defendant. So far, it's
Good morning, Your Honor. Alexander
Charges could
Hermanowski
change
with
all
and
that.
on behalf of Thomas Hornberger, who is approaching at this time. Mr. Hornberger, please state your name for the record.
Thomas Hornberg.
All right.
Your Honor, this is
Sorry, these double-sided are from the court yesterday. I got rid of them.
Okay.
Your Honor, this is time and date set for pre-trial. I've reviewed the case with Mr. Hornberger. I've had communications with the prosecution. At this time, there is an offer which Mr. Hornberger would like to accept. The offer is a dismissal of count 1 and adding a count 2 and 3, one of those for trespassing and the other one for disorderly conduct.
That is correct, Your Honor. That is the offer. The defendant is going to be pleading guilty to added counts 2 and 3. Added count 2 would be the disorderly. But may I just have one moment with defense counsel. Trying to ask him.
We're doing 2 charges?
Yes, Your Honor. The added count 2, the 90-day misdemeanor disorderly person, vagrancy, contrary to 750-1671 as in golf. And the added count 3, trespass, the 30-day misdemeanor, contrary to 750.552.
That's an approach.
Judge has some questions about this deal. He might not like all of it. Let's see. God, I'm trying to see that case. So, Katia sent me a link to a case out of Florida, Fort Lauderdale. 14-year-old girl accused of murdering her grandmother in Broward County. Charged as an adult, second-degree murder. Wow.
He said, let's have him sworn.
Not sure about that one.
Right here. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. State your name.
My name is Thomas Hornberg.
Sir, it is this court's understanding you're going to plead guilty to 2 misdemeanor charges. The first one being, I'll have the added count 2, disorderly person. That's a misdemeanor punishable by up to 90 days jail, up to a $500 fine plus court costs. Do you understand that?
Yes, sir.
The other charge is that of trespassing. That is a misdemeanor punishable by up to 30 days incarceration and $250 fine plus court costs. You understand that?
Yes, sir.
All right. Understanding all of that, you still wish to plead
Michael
guilty?
thinks he's on Twitter.
To that charge,
on Tinder.
Oh, to the charge of trespassing. How do you
Swipe
plead?
left on the judge.
Sir. To the charge of disorderly person. How do you plead?
Guilty, sir.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody promise you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
Doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
Because you believe that you're indeed guilty of these offenses?
Yes, sir.
Counsel, you want to inquire?
Okay.
Judge is tired. He's like,
on the date and time in question, it's 11/27/2009, location 3825 Carpenter Road, so right around Thanksgiving.
Mr. Hornberger, were you at a Meyer location on Carpenter Road in Ypsilanti?
Yes, sir.
And that was on the November 27th, 2019?
Yes, sir.
Okay. And at that time, you were asked to leave and did not leave the store?
Yes, sir.
Did you have a right
regards to a vagrancy? Do you agree that at the store you were engaging in vagrant behavior?
What does that mean?
Vagrant behavior. Judge is like,
actually,
why did they ask you to leave? Do you know?
Actually, I don't even really remember. I know that it was during the
Your Honor,
during the holiday weekend, and I had a little bit to drink.
Your Honor, this case did occur 2019. I'm asking if we could do a no contest on the second charge.
Isn't it already a plea?
Give me a police report. Let me pass it.
Judge wants to know what happens.
Sure. Have a seat. I'll get the police report and review it. Okay.
Mathis,
Thank you.
I'm pretty sure if I had OnlyFans where I
Court
just
call
read
People
Maya
versus Michael
documents,
Russell.
you would be my first subscriber. Thank you.
That's a lot of good people. Good morning, Assistant Public Defender Lauren Perny on behalf of Russell. Mr. Russell, please state your name for the record.
Michael Scott Russell Jr. Good morning.
Good morning,
Scott.
Mr. Russell would like to adjourn the pretrial. He wants to get out and try to get his license. I think at this time, though, he doesn't know he's getting out of Livingston County.
You want to adjourn it to a date he doesn't know so that he can get out and get his license? Is that what you're telling me, Miss Pirney? That's what I heard, but
that is what I'm telling you.
you want me to just put it into the future sometime?
And we'll just hope that Mr. Russell gets out and can get his license.
Okay, Mr. Russell, you say you've not been sentenced yet, sir. Is that it?
No, I have not, sir. I'm actually possibly seeking an order to under 257323 to petition the circuit court to stay the suspension. And
okay, I see. So
The judge's like,
when's your next court date on your
You're one of
Livingston
those.
County matters?
I'm actually not aware of any court date yet scheduled, sir.
Wow.
Well, he was recently bound over. You were bound over on the 11th, is that?
Yes, the 10th.
So it should probably be pretty soon.
I'm sorry, Don. That's hard to hear.
Pirney. Give me a November date. I'll do it for this guy. I don't know about Pirney. I'll do it for
November 6th at 9 a.m. or November 20th at 9 a.m.
Well, we may have to decide something else before then, but I get he wants to try to get his license. So let me do November what?
6th or the 20th.
November 6th, 2024 at 9 a.m. All right. We'll do it that way. It's fine. We'll continue.
Holly Mack,
Stay in touch,
congratulations.
Mr. Russell, okay?
Holly Mack,
Yes, ma'am.
congratulations
Have a
on
great day. Thank you.
Right.
15 months.
Thank you, sir.
Thank
Have a
you.
great day, sir.
Lisa, I'm just going to try to not
Court
talk
calls
over
case
people.
of the people versus Alyssa Burton.
Alyssa, here we go. It's Alyssa's turn.
Hello, Your Honor.
Respectful.
Hello.
Assistant Public Defender Natalie Pate, on behalf of Ms. Burton, who is present via Zoom, can you please state your full name for the record, ma'am?
Angela Burton.
Thank you, Your Honor. Today's the date and time set for pretrial. Ms. Burton wishes to set this case for final settlement conference.
Okay, Dr.
Jury
Browns.
final settlement conference will be
What's she here for?
October 18th, 2024, 9 a.m. Jury selection, if necessary, October 21st, 2024, 8:30. Both of those proceedings are in person.
Okay, thank you.
All right, thank you. Bond with this condition will continue.
Thank you, Ms. Burton. You can log off now.
Okay, before we go to the next one, we've got a couple things. First of all, has anyone heard from Brandy? Yes, she wasn't feeling very well earlier this week. She survived the storm just fine. I think they got spared a lot of the damage on her part of Florida. But she is going to be at the Sarah Boone trial, which is exciting. She's going to be doing what she does best in court, watching that happening. Hopefully we'll be able to connect with her a little bit. She might be checking in with us if she has some time. Lacey says, do you need a license to drive in different states? You need a license from one state to drive in any of the states. If you're just driving through, you're fine. But if you move to another state, you need a license from that state depending on the laws, within a certain number of days, 30 to 60 days of moving there, you need to get a license in that state. But I have a license in North Carolina. I believe you cannot have active licenses in multiple states because they each show that you're a resident in that state. So you have to give up your old state residence license when you get a new one. But there's a reciprocity. There's a big word that sounds something like what I just said. But that basically means that if you're licensed in one state, other states will honor that, even if the rules are a little bit different. So like my car does not have a front license plate, and it's licensed in North Carolina. I can drive that in North Carolina. North Carolina does not issue front license plates. Other states require front license plates. I can drive through that state and be okay because the state says, it's okay, you're not from here. We're not going to punish you for not obeying our law because you don't have to. You're not a resident here. Anyway, let's continue. Looks like Alyssa's
Court does call the case People versus Mark Elkins.
It's like recipe.
Good morning. Assistant Public Defender Lauren Kearney on behalf of Mr. Elkins. I'm not sure if Mr. Elkins is on Zoom, Your Honor. However, I haven't had contact with him.
You have not?
I have not. I have no explanation for his failure to appear.
So you're not asking for an adjournment to a undisclosed date?
Not this time, no.
No? Just checking.
Does anyone want to do some research on Alyssa and find out
bond will be
what her charge was?
$7,500. I'll give a 10% privilege. That warrant will issue immediately. There having been previous ones.
I apologize, right? Was it 10,000?
7,500.
Thank you.
Court calls case of the People versus Nyla Frazier.
Absolutely, the people.
Good morning, Your Honor. Alexis Zerb, student attorney seeking permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Lawrence Harney.
You're getting faster at it. This is granted. Go ahead.
Okay, Nyla Frazier just connected with either a camera out of the 1970s or a filter that makes it look that way, with terrible backlighting. But she's here. That's a good thing. She showed up.
Alexis Zerb is appearing on behalf of Nyla Frazier. Ms. Frazier, can you please state your name for the record?
Nyla Frazier.
Good audio.
Thank you.
Your Honor, I believe we've reached a decision to plead guilty as charged to the matter in this case.
Sweet tat, thank you. 8 months.
Okay, she's going to plead guilty to this.
Correct, Your Honor.
The record, people have no objection to fines and cost sentence. I apologize for interrupting.
Ma'am, is that correct? That's what you want to do?
Yes.
All right. Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State again for the record.
Nyla Frazier.
All right. Ms. Frazier, it is this court's understanding that you're going to plead guilty to the charge of open intoxicants in a motor vehicle by a passenger. That is a misdemeanor punishable by up to 90 days, $100 fine plus court costs. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, ma'am?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
You on probation or parole?
No.
Has anybody promised you anything other than what's been stated here? Well, has anybody promised you anything to get you to plead guilty?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
July 24th, 2024, at the location of Carpenter Road in Pittsfield Township, Washington County, State of Michigan. Were you a passenger in a motor vehicle?
Yes.
And did you have intoxicants in that motor vehicle?
Yes.
What did you have?
Alcohol.
Okay. What specifically did you have?
Like the brand?
Sure. Let's go there.
Don Julio, Reposado. It was a fifth.
A fifth?
Yeah.
Was the seal broken on it?
Like the top, yeah.
Okay, so
you have to drink it.
Man, was it open?
No, the top was on it, but the bottle was like halfway gone.
Because you had drank it.
Yeah.
Okay. And some of that drinking occurred in the vehicle?
Yeah.
Okay. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied. Defense is satisfied.
Should have been drinking better stuff. Anyway. Anything you want to say? Yeah, tequila. Just
no. No, sir.
Tequila?
Yes.
Why? Anyway. Yeah, anything you want to say on behalf of your client?
I would just ask for the fines and cost sentence, Your Honor. Ms. Frazier did indicate that she has new employment lined up, and it's actually in West Virginia. She's going to be a traveling CNA, so she would like this to be behind her so she can start that endeavor.
She's a nurse?
A CNA.
CNA. You're in West Virginia?
Going to be.
Going
Or
to be
planning
tomorrow
on it.
morning. Tomorrow morning.
You ever been to West Virginia?
No.
You're an Ipsy girl?
Yes.
And so, or woman, I should say. And you're going to West Virginia?
Yeah.
Never been there?
No.
Okay, good luck.
Thank you. Thank you.
I don't know, but tequila probably ain't gonna go over real well there. But anyway, fines and cost of $150. When can you get that paid? I'll suspend 90 days.
I can get that within 2 weeks.
All right, get it paid before the end of the month, October 31st. Okay, I'll give you till then.
Okay, thank you.
Okay, suspend 90 days. Good luck to you on your travels. All right.
Thank you so much, sir.
Okay, before he calls the next case, Kayla just called in, and thanks for everyone who gave us the case number and some information about Alyssa. Alyssa's case that we heard just a couple cases ago. Apparently, she got a little drunk and belligerent, so she's got a disorderly conduct and an assault charge. And she got bond 9/11 or something like that. Kayla, thank you very much for that. So,
Your Honor.
Interesting.
Court does call the case people with Christopher Gamble.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Gamble, who is present via Zoom. Sir, could you please state your name for the record?
Christopher Gamble.
Have reached a resolution in this case. Offer to the defendant.
Amazon
where
delivery?
He is going to be pleading to counts 1 and 2, operating under the influence, operating while intoxicated, with an occupant under 16 years old is count 1, count 2, child abuse 4th degree. Counts 3 and 4, also child abuse 4th degree. Those counts will be dismissed. There are no other.
That is correct, Your Honor, and I have relayed that offer to Mr. Gamble, and he wishes to accept that today.
So he's going to plead guilty to counts 1 and 2, counts 3 and 4.
Correct, Your Honor.
That's correct, Your Honor.
I'm not sure. Is that a Amazon delivery or is that just a construction? Jack, I can't see which one.
Please raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name for the record.
Christopher Gamble.
All right. Mr. Gamble, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
Yes.
First charge is operating while intoxicant with an occupant less than 16. That's a misdemeanor punishable by up to 1 year in jail, the $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. And understanding that, well, the other charge, I guess, would be child abuse 4th degree. That's a misdemeanor punishable by up to 1 year or up to probation for 5 years. You understand that, sir?
Yes.
All right. Understanding all of that, you still wish to plead guilty to these charges?
Yes.
To the charge of operating while intoxicated, occupant less than 16, how do you plead?
Guilty.
To the charge of child abuse 4th degree, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal upright?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes.
December 7th, 2023, at location of Platte Road near Morgan Road, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes.
What did you have and how much?
I had some cognac. I had a few shots.
All right. Bless you. Were you stopped by the police?
No, I was in an accident.
Ooh.
Okay. What happened with regard to the accident?
I was coming down a dirt road, so it was a little icy, and I thought I was basically pressing the gas, not like mashing on it, basically like just pumping on the gas to try to stop at the stop sign. But I knew I wasn't gonna be able to make it. But the car that was coming,
the wrong pedal.
I thought it was far enough back before I could turn out, but I timed it wrong.
So it was an accident. Police arrived at the scene.
I was pumping the gas, trying to stop.
Were you ultimately arrested?
He's probably telling the truth.
They took me to the hospital to receive treatment.
Okay. Okay, so they took you to the hospital?
Yes.
Did you have a blood draw?
Yes.
What were the results of that blood draw?
I didn't get any paperwork from the doctors when I was released. They just, I was there. They did my blood draw. The deputy that was there asked for the paperwork, and the doctor at the time said that they didn't have anything for him. And she called her chief, and then the chief told her to me.
Yes.
0.164.
I would stipulate to that, Your Honor.
Sir, do you have any reason to
There's
dispute
paperwork.
those blood test results?
No.
All right.
Double the legal
Were there
limit.
individuals in the car with you at that time?
Yes, my kid.
Okay. One child?
Yes.
I'm up here just for Mathis.
If I may, Your Honor, briefly.
Yeah.
Mr. Gamble, you had in the vehicle with you your children, correct?
Yes.
And how many
children?
How many children did you have with you?
Oh, I thought you was like, I thought he was asking like, did I have a child in there? I had my 3 sons.
Okay. Thank you.
I'm sorry about
And how old were the children?
that. 14, 6, and 1.
All right. Okay.
A few shots of cognac. Pumping the gas. Trying to
Counsel,
stop
have I
the car.
complied with the court ruling? Would it be proper? Well, I think that suffices for count 2 in any respect.
That was the
Have
defense
I
attorney
complied with the court
correcting the
ruling? Would it be
record.
proper to accept this
Where the
defendant's
client
pleas?
The people are
was misleading
satisfied.
the
Defense
court.
is satisfied, Your Honor.
Court will accept the defendant's pleas. Counts 1 and 2. Counts 3 and 4 are dismissed. Defendant is referred to probation. Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be October 23rd, 2024, 9 a.m.
I think I got a court date that day.
Pardon?
I think I have a court date for the 23rd already.
Yeah, you do. The one I just gave you.
No, for another for 14-8.
That is correct, Your Honor. Mr. Gamble does, I believe he's being sentenced. He is being sentenced on the 23rd and 14A2. I don't know what time that is, however, but I'm sure we can get that worked out with Mr. Gamble.
So what do you want me to do?
Um,
Give him another day?
I would not object to pushing the sentencing to another sentencing date, but I believe we would be able to make it work for the 23rd in this case as well, Your Honor. So I would leave it in your discretion.
But give me another day.
November 13th at 9 a.m.
Set a sentencing for November 13th, young man, all right?
Yes.
You'll probably be available.
2024, 9 a.m.
Especially if you're in
His
custody at
bond
the time.
will continue. All right, you need to hang on the line. We're going to put you into a breakout room with our probation department so they can begin the process. Okay?
All right.
All right. Thank you.
Thank you.
Your Honor.
Let's see what Anthony
Court does call the case of the people versus Anthony Haybecker.
Hey, he's next. I didn't know that. That was a lucky guess.
Court against the Public Defense Attorney on behalf of Mr. Haybecker. Mr. Haybecker, can you please state your name for the record?
Anthony Scott Haybecker.
We're asking you to set this for final settlement conference.
Judge is reviewing the case.
Jury final settlement conference. October 18th, 2024, 9 a.m. Jury selection. October 21st, 2024, 8:30. Both of those proceedings are in person.
Bond will continue.
Thank you.
Anthony, you got to be there in person.
Oh, no.
No.
Who's next?
Oh. Joe Hall. This shows up and it's getting bad. Just going bad. Court calls the case people versus Carlos Hicks.
Anthony doesn't know how to hang up. He's with us all day.
Assistant Public Defender Natalie, on behalf of Mr. Hicks, who I do not believe is present unless he's on Zoom.
He's not.
Your Honor, the number I had for him, actually, let me double check. I believe it was. Yes, it was. The number I had for him was bad. I did send him an email to the address I had on file for him. I did not hear back. I do not have an explanation for his failure to appear.
This is the first hearing, isn't it?
It is, Your Honor. It appears that Mr. Hicks was arraigned September order, give him a PR bond with a no-go to the Home Depot and total of this.
All I heard was something happened at the Home Depot.
Well, let's see, in order to show cause, we'll set that for, give me 2 weeks out of this. I don't care.
No bench warrant.
Put
Apparently,
it
because
at
he
a
might
pre-trial
not have
date.
been notified.
October 16th, 2024, 9 a.m. Thank you.
Thank you.
Because I don't see another warrant on him. Mohammed Ibrahim.
Good morning, Assistant Public Defender Laura Perry on behalf of Mr. Ibrahim. Mr. Ibrahim, state your name for the record.
Mohammed Ibrahim.
Do you have a camera?
And we're asking you to set this
There
for
he
final settlement conference, please.
Who's the
Very
gentleman?
final settlement conference, October 18th, 2024, 9 a.m. Jury selection, October 21st, 2024, 8:30. The way Pyrenees going, bring your lunch. Those are both in person.
Bring your lunch. Who's the guy in the gray suit behind the defense table? Like the first row of the gallery.
She's starting to get a little suspicious. Watch her, Alan. Court calls the case, People versus James Baltes.
Ashley Wally for the people.
Did you get that, Mr. Ibrahim? Oh, yeah, he's done. All right, he'll be here.
There we have it.
This is annoying. Good morning, sir. What's your name?
James Valtis.
Okay. Sir, you are before the court on a misdemeanor complaint that alleges that on or about July 22nd, 2022, at the location of 2728 Gulfside, Pittsfield Township, Washtenaw County, State of Michigan, that you did commit the offense of malicious use of a telecommunications service. You understand the nature of that charge, sir?
Yes, sir.
Prank call?
That's a misdemeanor punishable by up to 6 months incarceration and a $1,000 fine plus court costs.
Or a
Do you
threat.
understand that?
Yes, sir.
All right. First question I have for you. Do you want to be represented by an attorney?
Yes, sir.
This is a public defender case.
Good morning, Assistant Public Defender Laura Perry on behalf of Mr. Baltes.
Baltis.
We'll wait for the reading, stand mute to the charges, and request another pretrial date, Your Honor.
Brendan Hemingway, formal reading. Standing mute. Court
Christopher
will enter a
Gamble's
not
back.
guilty plea. Pretrial in this matter will be set for. Adjourn this matter to October 16th, 2024, 9 a.m.
Write your phone number here. It better be a good
Put the defendant's bond at a $5,000 personal recognizance bond, all other standard conditions, including no assault behavior or possession of any weapons. You understand that,
Must have been
sir?
a threat.
Yes, sir, Your Honor.
There's to be no use of any alcohol, recreational marijuana, or any illegal drug. I would also indicate, who is Angela Baltz to you?
She's my ex-wife.
And Your Honor, I was just about to address the court. I do think it should be on a Monday docket. This is between ex-spouses, so I believe it.
Is it marked as a
I don't
DV?
think it got stamped with the DV docket, but I am requesting that the court reschedule it on Monday, and I'll get an amended complaint to the court with the DV docket stamp.
DV docket.
Defense counsel, you're not gonna have an objection to that?
No.
Yeah. It won't have the 14th. It's gonna change the day.
For October 7th or October 21st at 1 p.m.
Let's do October 7th. Is there, sir, is there any reason that you need to have contact with her?
No,
Did kids?
she left me and her,
Don't
and
go
her
into the details, but
4 children 12 years ago, never came back. And like once a year, she'll call me.
Okay. So as between right now and whenever this proceeding may end, is there any reason that you need to call her, have contact with her kids? Any?
No, sir. No.
No? Okay, then what I'm gonna do is I'm gonna order this, there's be no contact.
Okay.
Okay? If she happens to call you, you hang up.
Okay.
Got it?
Got it.
And I mean no contact, indirect or direct.
Yes, sir.
No contact on social media or any electronic communication of any type. You understand that?
Yes, sir.
Anything else?
Nothing from me.
See you in a few days.
Thank you.
Court does call the case People versus Joshua. Is it Ozuski?
Ashton people.
Here. He is not checked in unless you're in order to show cause. Give me a date. October 16th, 2024, 9 a.m. Should have done it on this one, but not the other one. I'm not gonna worry about it.
Looks like Conrad Siller is here for Pittsfield. Pittsburgh. Who's the guy in gray back there behind the defense with the fine hair? Is he another lawyer? He's dressed really well. Got the pocket square and everything. I haven't seen him practice. Maybe he's a lawyer that's here to defend someone. I can see that there's nothing happening till right here.
House case People versus Thomas Hornberger.
Alexander Hermanaski with on behalf of Thomas Hornberger, who's approaching at this time.
iPhone 99.
The people are, based on conversations with defense counsel, it seems to make sense given the facts in this case. The disorderly would be the disorderly drunk, 7501671E.
All right. So I have a question. I understand what he just said, but I just read the police report. Where's the trespassing?
Your Honor, I'm not sure where it was in the police report. He did go there. They told him to leave, and then he didn't leave.
Okay, now we'll just do the disorderly. Thank you.
Sir, this change now where it's disorderly person is the only count. You understand that, sir?
Yes, sir.
All right. And that you're going to be pleading no contest to that charge. You understand that?
Yes, sir.
All right. You understand what a no contest plea is?
Yes, sir.
All right. Two things about it. I have to make sure that you understand all the rights I explained apply to a no contest plea. You understand that?
Yes, sir.
All right. The two things I have to explain is it means that you're not further desirous or wanting to contest this charge of disorderly person. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Still wish to plead no contest?
Yes, sir.
And to that charge, how do you plead?
No contest.
All right. The court has been providing and has reviewed Pittsfield Township Department of Public Safety report for their case number 2019-19002. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of count 2. Counsel thereby complied with the court.
Please look satisfied.
Yes, Your Honor.
The court will accept the defendant's plea to count 2. Count 1 is dismissed. There's no restitution in this case.
Yes, Your Honor.
There is no.
That's correct.
Anything you want to tell me before I impose sentence, sir?
No, sir.
You found a place to stay?
Yes, sir.
You got a
Yes, sir.
Over on Normal.
No, I live on 3024 Randolph Court.
Okay, so you got, okay.
Yeah, I have a.
That was different than when you were in this.
Yes, that's completely, that was a long time ago. Stable housing. Yes.
You working?
I'm on a disability, sir.
How much do you receive?
I receive about $1,500 a month. I did 1,500.
Fines and costs of $250. I'll suspend. Yeah. 90 days in jail. When can you get that paid?
I can have it paid beginning of the month. Beginning of
November.
Yes, sir.
All right, we've got
the 3rd.
Yes, sir.
We're going to put this on hold just for a minute, and we might come back to Judge Simpson's court
today.
today.
150 November 3rd, then $100 December.
Yeah, he's got to pay his fines.
Well, it's November 4th that you have to pay because it was Sunday, and then pay the other 100 December. Just break it apart.
Thanks.
Okay.
All right, we're going to pause this just for a second. Our newest moderator, Josh, in an attempt to prove his worth, has been going above and beyond, finding us just some amazing cases. And we've got one that happened just this last week that flew under the radar with Judge Oakley, and it was a soft sit. It was a soft sit, which we love. Sorry, didn't mean to bump that button. Let's turn that off. This on. Go there. Shut this window down. Okay. So we're going to go to Judge Oakley's courtroom really quickly and see if we can. Let's see. How does this work? Where are we at? Okay. Let's start right here. Give us just a minute. I have not seen this. Now, Josh gave me the instruction to watch this and have just a completely straight face.
We're done with this part. We have everything, all the jury instructions and everything is on an iPad. So I'll go over that with you. It only takes a couple minutes, but just so that you know what everybody's going over.
I'm excited already. I've not seen this. We're trusting Josh because he's come through clutch many a time before. Bailiff brings in the coffee. Everything's getting ready to go. I think one was his, one is the judge's. Looks like the lady in blue over there, that looks like the prosecution. The table closest to us should be the defense table. I think the defendant was the person who walked in gray and just sat in the corner just moments ago. I hope Josh isn't committing crimes to create content, says Bob Cousins. Josh is amazing. We summoned him to serve us.
Court now in session. Honorable Judge Oakley presiding.
Straight face.
Come on, Mr. Cassell. You folks can have a seat.
Here we go. Hang on. Let me make sure.
Hired appearances for the township.
Let me make sure the speed is not on high because he is talking super fast. That's on normal. That's normal speed. All right, he's just a fast talker.
Have a seat. Make yourself comfortable. All right, so Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to address the request of the judicial bias and the process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crucell?
Well, it's covering all the judicial bias.
Okay, listen to my question. Is it any different than the last motion to stay proceedings you filed? Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
I just have a statement straight face on you. Didn't give a shit about what I have to say.
Okay, hold on. Mr. Cazell, this is going to be a very long day for you. if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers Judge Gene Green telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago.
That's not the way it works. Mr. Cooper, hold on. Okay, that's the last time you're going to interrupt me today without a contempt of court charge. Is that clear?
Your Honor.
Is that clear?
Prosecution against me this entire time. No one has made her answer.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept?
You're supposed to be impartial.
I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
Absolutely means if you're agreeing with that, definitely means you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Crucell?
I can't do straight
No, you
face.
have to answer my question. Contempt number one, $100.
Cha-ching.
Answer my question. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes or no? Because I can do this all damn day. And when I get tired of this game, then I tell them to put you in custody because it's contempt of court, criminal contempt in my view.
Yes.
It is. All right. So now, any argument you make from there, I'm going to deny because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making.
What statement is that?
It was.
I thought we were talking about Judge Green's SOS statement.
When you made the statement that you were setting aside my regular trial, saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting that all aside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my point and setting it aside, what you were doing.
Mr. Crucell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
Dog and pony show. This court has failed to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt. Anytime I tried.
I am threatening you with contempt.
My objections on the record. You make my case.
No, because third contempt. Do not interrupt me. When I said your objections don't mean shit to me is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence. And you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a proper legal objection. When I rule in her favor and you say I object and I say, what's your objection? And you just disagree with me, that's not a legal objection. That's why I said your objections mean shit to me because you're not using the word appropriately. Because you don't know what you're doing. That's what I tried to tell you originally the first time you were here. You've never been to law school. You've never tried a case. You don't know the rules of evidence and all the other things that have to be in play to have a trial go forward appropriately, properly, and to be perfectly honest, in your best interest.
And Your Honor, again, you're trying to spin this here every time I'm making.
I'm not spinning.
My objection is based on you stopping me, not allowing me to do it. And that's when you told me my objection to me.
Okay. All right. So let's do it this way. Let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she's never once it's on the, why it's on the prosecutor to prove those things. There's all sorts of irregularities.
All right. Let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking place now shows exactly that there is enough to show. You're supposed you need to keep sure.
Once again, you're not answering the question I asked. You just said you will not participate. And I asked, what do you mean by that?
Fair trial.
I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me getting all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
Put on the record that whatever you would like to do from there, you can, because I'm open until these things. Like I say,
Hold on. Is this statement preceding all these motions you filed? Okay, then let me make my ruling on all of them. I think there's a motion to dismiss for lack of jurisdiction, correct? Okay. Would you like to respond to that one? Because I think that's already been addressed.
Please arrested Mr. Crusoe while he was in Huron Township, 34th District Court has jurisdiction over offenses that occur within the township, both civil and criminal. This is criminal and
Did you appeal Judge Green's decision on that motion?
I'm investigating it because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct? I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
Yes.
Thank you. Next motion. Motion to...
The judge can't just come in here and say that there's...
Yes, the judge can. Listen to me. Then appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
All she said was that Judge Martin was setting aside and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And anybody have all the recordings and were submitted to the court. These things were never said to me. And then she comes in here and makes these accusations and saying that the judge said this, the judge said that.
Fine. Then I'll say the same. I'll say the same thing to you. Listen to me. Here, on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me. Because the reason she stated, the Township of Huron issued you a citation. This court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay. Okay. Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today.
Gracefully broken mom, congratulations.
I really would.
Thank you so much.
Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant, because that's my job as the gatekeeper after the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge, not because I don't like Mr. Crucell. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling. That's not a legal objection. So that's 2 motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside your defaults. All right. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside, defaults that were set aside are reinstated. Is that really what you want today?
Well, listen, Mr.
Crucell, yes or no? You filed a motion asking me to set aside a decision that was made. Do you really want me to set that decision aside? Because that means those civil infractions are then in default and they're done. Is that a yes or no? Yes or no? Do you want me to set aside those do you want me to set aside the default set-asides? Do you want me to reinstate those default judgments? Then I'll deny that motion. All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution?
Shut your mouth. Counter.
So am I. All right. The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
Essentially, yeah.
Okay. Okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent. Oh, excuse me. Motion for judicial notice. What does that judicial notice of what?
Certain terms that this prosecutor keeps trying to use and apply in this case that are not the law terminology being used. Okay.
For example.
You use motor vehicle.
Okay. Motor vehicle's pretty much a term of art in our business.
Law differences between how it's being used. Absolutely.
Well, then you can make those arguments. But you can't tell her she can't use that phrase. Yeah, but I'm not the trier of fact. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, you can make that argument. Is that what you're concerned about? Is you're not going to be able to make the argument?
Yes.
Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions.
All of this has to go. Everything that's taking place.
No.
Exactly.
No. That's not the way it works, Mr. Crucell. No. Mr. Crucell. All right, listen. Brother, listen. You don't get to tell me what my job is. I've been doing it for 25 years. Listen. Well, then that's why they have appellate courts for the 4th or 5th time. I decide what this jury gets to see today. I decide. That is, by definition, the role of the judge at a jury trial. I get to decide what goes in front of that jury. If you don't like the decisions I make, you appeal those decisions. That's the way it works. What this jury has to decide today is whether or not you violated the township ordinance on that date. Hold on. None of these legal arguments about whether or not I should recuse myself or whether or not you notice me up for constitutional rights, none of that has to go to that jury.
This is Michigan.
And none of it's going to.
That's the other issue of the trial and emergency motion to stop this.
I already ruled on that.
Certain back. Acknowledge my motions for my next travel.
Once again, I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. And you can disagree with me that all day long. But we're going to do it, once again, we're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I encourage you to appeal me. All right. I am open-minded enough to think that perhaps my mindset about your whole travel thing, maybe that's all wrong. So a circuit court judge can tell me I'm wrong. But so far, and I've ruled this way a number of times on the traveling issue, nobody's ever appealed me to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
I said, well, you just keep, each judge has done the same thing. They just keep setting aside, and acting like it doesn't exist, not allowing me to make my case, which is violating my rights to be able to produce my case in my head.
What's your case that traveling doesn't mean operating?
I'm accepting the fact that this court's violated my due process rights in every way, the judicial bias and the fact.
All right, then appeal me. But today we're having a jury trial.
An unlawful jury trial, and I think that a late statement I need to get on the record.
All right, but hold on a minute. Once again, I want to know what that means. You're not participating.
Not participate in a jury in a trial where there is clear bias in this court against it violates my rights to a fair trial. 100%. And you want to keep overlooking them. I know they make you seem like they're not a big deal. And
no, your rights are a really big deal.
Obviously not, because if you can sit there and say that the things that are happening, the things you're saying, and just try to give these excuses, just because I agree on this, you are aligning yourself with the prosecutor on my right to trial, completely setting aside, not allowing me.
Mr. Purcell, no, I'm not. Listen to me. No, it's not. Listen to me. Listen to me. She could step out of the room, and I still think your travel argument is bullshit.
Soundbite.
Traveling. The right to travel was when you did it by Shanks and Mare. Then appeal me. That's my decision. Appeal me. When you're driving a motorized vehicle or traveling in a motorized vehicle, that brings all those ordinances into play. That's my legal ruling. Appeal it. I encourage you to do that. But that whole traveling argument, which, dude, I've been through that argument a whole lot more than you have. Trust me, in the last 25 years, I've had that argument a lot. Traveling as you try to apply it meant you could not be stopped by the government from walking from one venue to another. But when we got motorized, then the rules kicked in.
Rulings from the American Jurisprudence side that literally stated that yes, first of all, you're allowed, and including automobiles, as long as one does not interfere with another's rights. And this is something that is not to be secure.
Then appeal me. Take that precedent and appeal me.
As well.
Okay, that's your right. I'm not trying to stop you from doing any of that stuff. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today.
Because just because you're determining it based off of what though? That's what I'm saying. All these things are relevant and they are accurate.
They're relevant to you. They're not relevant to me. I've made the decision. I have made the decision. I made that decision months ago and you didn't appeal that.
I mean, the process is working out.
Which is not an appeal.
Is an extreme, lawyer when there is bullshit that you can't do that.
Absolutely, I do that.
100%.
No. Listen to me. Listen to me. If I don't hold you to the same standard I hold her to, then I'm treating you differently than her. How is that unbiased and impartial? You've decided to engage yourself in this venue, in this arena. That means you got to know the jury structure. Yes, you have.
I'm forced to be here.
But you didn't have to do it. You didn't have to do it as an untrained layperson. You had free access to qualified, competent legal counsel. They're still here. There's one right there behind you. He's still ready to help you. You chose to do this yourself. That means you've got to know the court rules. You've got to know the statutes and the ordinances. You've got to know the rules of evidence. And if I help you through those lapses in your knowledge base, that's not fair to the prosecutor. Then I'm taking sides. And now I'm not going to let her walk all over you and try to trick you because you don't know some of those rules and statutes. But I am absolutely going to require you to know what you're doing because you've chosen to do it. That doesn't show bias. That shows impartiality.
Boom.
There's no partial anything. I have the.
Once again, Mr. Crusoe, that's your opinion. No, it's your interpretation of the facts. So you have to appeal my decisions. And look, dude, the fact that you're not in a jail cell right now shows how impartial I am.
When Officer Price literally pulled up to me, my wife had days before any of this even happened, and talked to us about the traveling. Even told me I was well within my rights. Gave me every clarification I was well within my lawful rights. This was all a retaliatory thing from the beginning. And then even when the chief called me. He even called me trying to oil arena. I was like, well, it's not ORV. And then he goes to the motor vehicle. And then he tries to get me to not pursue legal matters. And then he gets mad at me. And then the day that I file for my body cam, I'm getting removed from here on a Little League.
And stop. Hold on. I don't doubt that it is. But I think we got into this a little bit the first time you were here, and I told you that's not proper for this venue. If you want to complain about the way the Huron Township Police Department handled this, you can file a civil lawsuit against them if you want to. But what's in front of me is one civil infraction and 2 misdemeanors. That's what's in front of me.
Oh, every time I force it to make my case, basically, the court keeps setting all my stuff and not allowing me to be heard.
Because I'm going to make decisions based on the facts. That jury hopefully is going to make decisions based on the facts that are presented.
How will there be facts if this court continues to not allow me to get my facts?
Because the facts you want to get into,
are not relevant.
What facts do you want to get into? The chief had some conversation with you?
It's not even just that. I mean, well, yeah, regardless, I have all of that to cover too. The fact that my offense, based off what I was doing, I didn't have to produce any of that. It just keeps all just thrown aside. Every single bit, and just not even trying to acknowledge any of it.
So hold on, I don't understand. Hold on, you want to be able to testify to this jury?
No, it's not. I'm not testifying. That's what I'm saying. It's the amount of traditional bias in this case.
I'm done hearing about bias. You need to appeal me. I don't feel I have bias.
Okay, well, I don't feel that I would have a fair trial here with everything that's been taking place by the final policy. Why did we?
And I've denied all these things.
Well, of course you can deny it. Again, showing them again.
Once again, Mr. Crusoe, just because I disagree with you doesn't mean I'm biased against you. Maybe I just think you're wrong. Is it possible we could have a difference of opinion?
Tina Green told me that she was just not acknowledging myself because the Secretary of State will make sure that this isn't a big deal. I'm showing them.
I'm not going to.
It's no impartial sport here.
I've never brought a Secretary of State, have I?
This is where this all stems from. These are the things I've been trying to get noticed. This and talked about.
What do you want getting noticed that we're not getting noticed?
The fact that this collusion
is not collusion. What? All right, listen. What are you going to do today? Because I'm ready to bring the jury, and I've denied all. Stop! I've denied all your motions. I'm ready to set the trial. Are you not going to be here?
It's not again. Your Honor, as established, nothing is even floating in here, right? And especially regarding the jurisdiction stuff.
Once again, we're at $300 now. We're going to 4. I'm going to ask you the question again. I'm ready to call the jury. Are you going to leave?
There's no way they're going to be fair trial.
That didn't answer my question. I need to know how I'm going to proceed because we can have the trial if you just sit there. I'll just tell the jury you've decided to represent yourself and you might not say anything today. So that's the way you want to go with the trial.
I do. So it's against that.
Okay.
Everything is on the record.
Okay. Okay. No, let's on the record as you feel they should be.
This guy's here just for lunch. He's like, I'm bringing my popcorn. I'm going to watch this. Gerald. He's like, I'm just here to watch this train wreck.
I left the sites at home and bring up the person's jurisdiction.
And hold on. Once again, I want to because he just walked in the room. Once again, I want to let you know there's a very competent, experienced legal attorney here, defense attorney here, that's more than willing to help you with this if you want his help.
Well, the sport actually was supposed to be.
And that ain't going to happen.
Anybody showing you were supposed to recuse yourself. It's in the book.
And I don't think I've shown bias. That's what we keep. Once again, you and I disagree. That's okay. That's America. You have to appeal me. You don't just keep to argue. You don't get to argue the same thing over and over and over until I agree with you. That's not going to happen. I know I am not biased towards you. I also know that your ideas of how the law applies in mine are vastly different. But because I'm in the black robe and I'm in charge of this trial today, my ruling stands until a circuit court judge or some higher court tells me I'm wrong. That's just the reality of it.
That's what I have to do, because this court's not gonna rule it the way it's supposed to. I'm not gonna stand by your urging.
Not by your definition, I'm not.
Secretary of State and Attorney General, and sent to you. I've never heard anything. I don't even know if you're lawfully allowed to concede it. You can say that again, and it's been proven on the record.
No, it doesn't need to be
This
proven on
guy's
the record.
currently waiting for court with
show me a
Simpson, so I
statute
brought
or a
him in
court rule
here.
in Michigan that says I
He's
got to
just
prove
eating.
that. Statute, Michigan statute, or Michigan court rule says I got to do that.
I have it in there. My father's in smoking.
So you're such a great legal scholar.
MCL 168.420 and MCL 168.467 mandates that the judge must file with the state, and you provided 1X. That is what you have to ensure.
Okay. Then I don't have it. You can file that motion to dismiss with the circuit court.
Gerald's live in Simpson.
But we're having a trial today.
This Oakley judge is a couple days ago.
That's going to be impartial against me, but it's going to be completely. There is no impartiality that is supposed to be here. There cannot be a fair trial for all of the amounts of evidence that I have.
Okay. Anything else you want to put on the record before I call the jury in?
Yeah, lengthy statement I would love to put on the record before we get.
How lengthy?
Minutes.
Go ahead. Just so you know, you're putting this on the record. You're putting this on the record. I'm not listening. Showcase the record.
Your Honor, Judge Oak, I respectfully assert this court is
He walked out.
By files of the case. Yeah, well, down so she can make. I respectfully assert this court is failing to address the critical motions I filed in this case, including the motion to dismiss for lack of jurisdiction, the motion to recuse for bias, and the motion for relief from judgment. These motions have raised significant concerns about the court's jurisdiction, judicial bias, and violations of due process under both the Michigan Constitution and the U.S. Constitution, particularly the 5th and 14th Amendments. I have also submitted affidavits and motions, including an affidavit of truth and an affidavit of rebuttal regarding the traffic stop by Officer Merrill, which is connected to this case on August 21st, 2023. Citation number 24HR-101-430, which this court also ignored. These documents directly challenge the jurisdiction of the state in this court, and failure to address them constitute a violation of due process rights. Additionally, I have filed an affidavit of not consent, a motion for judicial notice, a motion for clarification of accuser, none of which may be outside the court. In Marbury v. Madison 5 U.S. 137, the U.S. Supreme Court clearly established that any law repugnant to the Constitution is void. I believe the action or lack thereof of the court violate fundamental constitutional principles. In Murdoch v. Pennsylvania 319 U.S. 105, the court reaffirmed that no state in
We'll go back and watch
for
Simpson
exercising a constitutional right. And Thompson v. Smith 155 reinforced that the fundamental right to travel freely without undue interference. Additionally, Title 5 U.S.C. 556D, 557, and 706
Judge is out washing his car
require
right
any
now.
judicial or administrative proceeding be fair, free from bias, and based on factual evidence. I have serious concerns that this court has disregarded this evidence. I have serious concerns this court has disregarded these principles, given its pattern of dismissing my motions and statements made by Your Honor, who has stated on record that we see things the same way, referring to the prosecutor, township, state, and this court. This admission clearly demonstrates judicial bias and lack of impartiality, which undermines the fairness of these proceedings. It is also significant that Judge Tina Green has admitted in court that the Secretary of State is influencing the rulings, stating that the court is required to enforce certain rulings because of the Secretary of State makes them do so. This further demonstrates that this court is not acting as an impartial judicial body, but is enforcing motor vehicle codes, other rulings based on external directives rather than applying the law independently. The Secretary of State is an executive branch agency, and his influence over judicial proceedings is a violation of the separation of powers and the constitutional right to an independent, fair trial.
Prosecutor has to sit here and listen.
Between sport, prosecutor, Huron Township, including the Huron Township Police Department. I have submitted body cam footage highlighting violations of department policies by several officers, including Officer Merrill, Officer Syside, Officer Smith, and Chief Everett Robbins. These violations occurred even after Sergeant Price confirmed that my activities were lawful. Yet this court continues to overlook these crucial facts. Officer Merrill's traffic stops of both myself and my wife are connected to the ongoing retaliation against me and my family, which has compounded the bias and misconduct in this case. Additionally, I requested Your Honor's oath of office through an affidavit of fact. Legislation statement, demand request pursuant to the Foreign Agent Registration Act of 1938 and anti-bribery statement request, and I have received no response. This lack of response raises further questions about the legitimacy and legal standing of this court. Moreover, Judge Lisa Norton issued an unsigned default order without jurisdiction or court seal, and during court proceedings, she admitted she did not understand the sui juris. These actions reflect further incompetence and violations of due process. I must also address the township's deliberate attempt to mislabel my private automobile as an off-road vehicle under local ordinance to circumvent my constitutional right to travel. This mislabeling is an attempt to subject me to commercial regulations that do not apply to private, non-commercial travel. This ORV ordinance was never intended for public roads. Under the Federal Trust Code, or United States 318 U.S. 363, when government entities operate in a commercial capacity, they lose sovereign immunity and are subject to the same legal standards as private corporations. The court's actions, including the misapplication of commercial motor vehicle codes, further demonstrate its commercial interest in misinterpretation of the law. The supremacy clause of the U.S. Constitution, Article 6, Paragraph 2, mandates that this court is bound by the Constitution, which is the supreme law of the land. This court, however, continues to proceed without regard for constitutional protections, violating my rights at every stage of these proceedings. To continue under these circumstances would be a violation of my constitutional rights and an abuse of judicial power. I respectfully request that the court issue rulings on the pending motions, including the jurisdictional challenge, they immediately dismiss this case by citing overwhelming evidence of judicial misconduct, bias, and due process violations. So these issues remain ignored. I will see immediate appellate relief, hold all parties accountable, including Your Honor, Judge Martin, Judge Tina Green, Prosecutor Caitlin Margaret Foley, Officer Miro, Officer Sisai, Officer Smith, Chief Everett Robbins, and the Huron Township Police Department.
He's
I
suing the whole
further
town.
assert that if this court continues to proceed with the presumption that I am engaged in commerce, it must present evidence to substantiate his claim. Without such evidence, this court has no authority to enforce commercial motor vehicle codes or ORV ordinances upon me, and any further actions would be unconstitutional and unlawful.
He could have been reading that in the broom closet for all the difference that's going to make. It's all he can do is he going to get up and walk out. Somebody page the judge. There's
All right, here report this report back in session.
Bring the jurors in.
Bring the jurors.
Mr. Crucell, just so you understand the process, we're going to do voir dire. Did you have a chance to talk about the iPad?
No.
Hold on a minute, Joe.
Hold it,
Yeah, I
Joe.
told him I would go over it.
Okay. I understand that's your position, but I'm still going to explain things as they go. All right. I mean, I just want you to understand what's going on. So if you decide you want to jump in, you'll know where you're at. Understood? I'm not trying to talk you into participating. I'm just letting you know what's happening. I'm going to explain things as we go for you and them. You got that?
I suppose I don't understand why I need to sit here and use my time for an
Because if you leave, I'm going to ask you a bench warrant, and you're still going to have to deal with this down the road. At least this way, listen. Here, one of two things can happen today if we have the trial. Either they find you not guilty and you're done, then you can file all your grievances and stuff, or they find you guilty and you're just filing one more appeal.
Well, instead of wasting everyone's time,
You've already wasted their time because they're all here. They're all here.
well, that's why I filed these things weeks ago. These things should have been addressed before this process even took place.
There's a scheduling issue that takes place too. But hold on. Hold on. Don't interrupt. You didn't appeal the last round of decisions. You didn't appeal the decision you didn't like from Judge Martin. You didn't appeal the decision you didn't like from Judge Green, and you didn't appeal the decision you didn't like from me last time you were here. So here's my problem. I'm not going to adjourn today because you say you're going to appeal, because if you don't, we've accomplished nothing and we're no further to resolving these files.
I can't make that had to file with the appeals court that I've been in contact with the appeals court.
Okay. Okay, so hold on. Let me try to educate you, okay? You contacting the appellate court, first of all, this should go to the circuit court, all right? You've gone, okay. So I didn't choose for you to be here, but you're here, okay? So we have to get through it, all right? So the way it works is you don't just talk to them about an appeal, you actually file and perfect an appeal, but you didn't perfect the appeal. So there is no appeal. You started the process, but there is no appeal. So we're going to go forward today. The only question is, are you going to be in the chair or not?
No, again, if you wish to amend for, I'll have to state a bond one, correct?
Depending on what I set the bench warrant at. It can be whatever I want it to be. Once again, but see, you think that's bias, right? And that's me explaining to you the way the process works. I could set a $10,000 cash bail on this. And until a circuit court judge tells me that's got to be set aside, it's the bail. That's the bond I set if I set it. Because here's the thing. And I'm trying to, listen, dude, I'm trying to get you to see I've got a job to do. It's got nothing to do with you personally. All right, you keep bringing this, I'm having so much trouble getting through to you. I'm thinking the next step is a competency exam.
So that fact that she told me that on the record in front of her, and in all the things that she's saying, the judge said, she never said that on the record. I have the record submitted.
So once again,
she wasn't doing this because of the Secretary of State.
Then appeal Judge Green's decision. I've told you that at least 5 times today. If a district court judge makes a decision you don't like, you appeal it to the circuit court. You don't just keep arguing again. That doesn't get you any further along.
He doesn't want to play their game.
So if you don't participate today, if you just sit there, that's fine. We'll have a trial. You can jump in if you want to. You don't have to. I mean, in any criminal trial, the defendant doesn't have to do anything. But at each step of the game, I'm going to let you know what your options are. So, for example, when we do voir dire, I'm going to ask questions of the prospective jurors. She's going to ask questions of the prospective jurors. You can ask if you want to. You don't have to. All right? When it's time to pick the jury, she has a certain number of challenges she can use. So do you. You don't have to exercise those challenges, but that's the way we pick the jury. Do you understand that process?
I've been trying to get all this stuff established as a course of contingency. And I still have evidence that I'm trying to get from the township that they're using lead codes for that, which they did with the policy information that I gave and got them giving me the policy because they were trying to explain stuff.
Okay, stop right there. Hold on. Stop right there. Stop right there. That's something new evidence you're waiting for. What are you waiting for?
This is where I haven't got it to even get to.
No. Tell me what it is. What
evidence that was that I requested from FOIA's in the very beginning with my bottle camera.
No. But well, what is it? You're looking for some records, some ordinances?
What are the traffic comments and things that were put in there? That
hold on. In where?
In the comments.
You don't have police reports?
Well, I do, but I found out that they withheld certain documents that when I filed my FOIA, they didn't give to me. And then upon doing more filing for more stuff, I uncovered that they withheld certain documents. Okay. That are getting the whole thing.
Hold on, let me hear what you just say. Just hold on. Go ahead. Do you have any idea what he's talking about?
He's pointing things from the south.
I wish they'd mic these people.
You mean like the officer's personal notes? Had notes.
And for example, body on camera where they're sitting in their patrol car and the computer's on. Those are all lean material that can't be discoverable. It can't be shared with people outside of those that are have the security clearance to observe or handle the material. So that's what he's referring to.
Okay.
That's not what I'm referring to. The notes on the computers and stuff, that's not what there's even stuff that was in the body cam that when they were talking to the chief that they purposely redacted out of the conversations. And the notes that that are completely all redacted. It's nothing to do with computers. It has nothing to do with personal information and names or addresses. There were things that were stated in conversations that were taking place in these notes.
Let me stop you. During the traffic stop?
They withheld this when they should have given it to me in the very beginning with my FOIA for everything that's involved in my traffic stop. They
Okay, hold on. I'm trying to clarify. Are you talking about like, I don't want to say this. Personal comments between two or more individuals?
No, it's not personal comments. It was stuff that's logged through the traffic stop. Like,
No, stop. But I got to understand what you mean. Logged through the traffic stop. You mean it showed up on camera and then they edited the camera?
Yeah.
Or edited the recording?
As well. And there was no clear reasons why. Every time I try to get reasons to why they did it, what it's next, because they're supposed to label why it is. I haven't got anything. And then it's in the comments sections of like what was going on.
Hold on. Comments on the incident report?
It's not the incident report. It was through the, while the traffic stop was taking place, stuff that was being entered through, like, I can't remember exactly what the paper is I am. Like I said, I'm in the process of getting it all. I'm appealed it to the supervisor, and then he vaguely gave just cited statutes and codes, but he was supposed to tell me how and why I didn't even see the applying to the lead sections, which are failing to do because same thing with.
All right, so hold on. So what I'm hearing, I want you to confirm whether or not I'm hearing it correctly. I think what you just said was those comments section things that you want, they're telling you that's all lien stuff and it's protected.
Yeah, it's like with other, I have other.
Hold on. Is that a yes? That's what they're telling you?
Essentially.
Okay.
So, and I didn't, part of it, because I had a whole thing of paper I got from them. They didn't do it in any of the other ones. Only.
Hold on. Other one what?
All the, because there have been several reports, several times the cops came out of their house, and we were told, well, this has been going on for all of the year, probably why it's even happened.
Okay.
So I filed every cop that had been there, all the reports, anything to do with anything that I could get that was access to me. And then that's how I found out that these other reports weren't released to me. And then in my life traffic stop, they did the same thing. Everything to do with that entire traffic stop is all completely redacted. We got any of the other stuff, it's all open.
Redacted from
The whole page is just black.
hold on. Redacted from the incident report?
Yeah, from the incident.
The paper report that you received?
Yeah, exactly.
Okay.
And there was no justification involved why any of these things are redacted. I keep trying to, and how they did it with the policy. I tried to get the policy 3 separate times to the department, and then they cite these lien codes for names and addresses and stuff, which I understand there's certain stuff.
What policy?
The policy conduct for officer conduct and how the officer's supposed to operate and stuff, right? So they denied several times, stating the same lien codes are trying to fix all these connections now. So I appealed it to the township supervisor, and he released all of my information. And it showed that the policy showed that these officers violated the policy. And
okay, hold on. Stop.
confusing
So he
things.
released everything, but not everything you want?
Well, then once I realized they were doing this, I went back to getting more. That's how I found out there was more stuff that was never released to me.
Okay.
And then they're doing the same process using these lien codes to not let me see what was put in this paper. And that's why it's all American Titans. I've been trying and fighting all this whole time, trying to get this stuff together. And I'm getting every which way, I'm being screwed.
He edited that. I'm getting stymied.
He's raising issues that concern me.
Yeah.
Because now we're talking about discovery requests that are being
legitimate,
partially fulfilled.
As it is with this stop, he does have the incident report. He does have body on camera for 4 officers in car, dash cam, what have you. He also personally took a video. I don't have it. There was no mutual discovery. He elected to use the FOIA route to take all this information. What he's referring to again is the CAD information where there is no material. None of that affects what the substance of the incident report or the body worn camera or anything of that effect. He's also talking about incidents that I think they were probably about, the township attorney is dealing with it as opposed to the township prosecutor. There's probably about 20 different contacts that he has sought FOIAs through. So it's not just this incident. And what I suspect he's talking about where police may have came to his house or like a traffic stop or speeding ticket, there are no incident reports. Those are CAD notes. So that's probably why those are blacked out as opposed to this incident where a misdemeanor was attached and an incident report had to have been written.
Okay. Anything else as far as information you requested that you don't have that you think you need?
I mean, that's the base of it. I'm still actually, now that I've been having to really dig into stuff, I'm uncovering more now that I've been through the body cams. I have to file more to get more stuff unredacted because there is clear points in these conversations that were purposely redacted. They have nothing to do with clean information that they keep claiming. Same thing with these cat notes she keeps referring to. That's not what I'm trying to get hold of. And I understand that there are things that they can redact through the lien code. These entire things that are, there's no way the entire pages and these comments and everything are all lien information. I know that. I've even told.
How do you know?
I've been told for Sergeant Price, things that are said in these personally about me and stuff like that are being redacted because it can be used showing the bias and everything, the retaliation against me. And I know for a fact what was said of these things. That's why I know that being redacted is more than what you say.
He's got a strong argument.
But Mr. Crisell, with all due respect, that all sounds like a civil lawsuit against the township.
Yeah.
Well, yeah, this is my argument. I'm trying to bring into this court, but everything's just being keep getting.
Because I'm not going to get into all that with a jury.
But that goes directly to this, is what I'm saying, and that's why I've been trying to get all of this stuff answered before we even come to this point.
I'm not going to let you get into all that with the jury. It's going to be confusing. We're going to go down rabbit holes.
That's why what's prepared, because I need to be able to present my case. Just fair. So
This case goes back to February. We set this trial 2 months ago.
You're right, but
2 months and 2 weeks.
I'm trying to get the jurisdiction established. I'm trying to get the judicial bias stuff taken care of. All of these things that have not, that they've just been it is what it is, getting swept under the rug.
Okay, hold on. Once again, I have to take offense to that.
Yes.
I have to take offense to that. I'm not sweeping your judicial bias argument under the rug. I'm denying it.
I give it to you. Yes.
Okay? No, seriously. See, it doesn't matter what you have to say. If I'm determining bias, I know what my heart is. Now, you appeal that decision or you grieve me to the Judicial Grievance Commission, right? They can look at all your facts and say, well, Oakley, clear bias. But I don't have to hear all your arguments and see all your evidence to know I'm not biased.
That's fine. I guess that's the and I have already started to do a process and I will be going down it. The more I look at it,
okay.
So again,
sir, it's 9:02. The jury's been here since, I'm assuming shortly after 8, some of them were showing up.
Yeah, like I said, I cannot participate in something that I know is stacked against 100%.
Well, once again, you think it's stacked against you just because you don't agree with the way things are going. Okay.
They're going to show that these things have to be established. There has to be any.
Then
you see, bias like that.
Okay, stop. We're just hashing the same arguments again. If you're right, then you've got an automatic appeal if they convict you today. If you're right, and this whole thing has been nothing but a sham.
It has to be, and it's all this turned into.
Okay, bring the jury in. I'm tired of talking. Motion who? Oh, I forgot you filed a motion. Give me just a moment. Yeah. Did you see that? Hold on. Did you get her motion?
I never seen that.
Yeah, no. You got a copy? You can just at least show him so he can see if he's seen it before.
This is interesting.
When did you send this to me?
Last Tuesday along with my
I have never seen this.
You just
take a minute to look at it.
If he's right about this discovery violation, he could win a civil lawsuit and win money from the city. But it sounds like he's first going to be convicted for driving without a license. So he might be convicted and win money from the city because of how they handled it. There might be some bias and retaliation on the part of the police, some improper discovery methods, improper redactions where they took things out where police officers might have treated him inappropriately. If he can probably win that civil suit, but he's going to lose. He's going to lose this criminal suit, I think. It's a criminal case. Man, Judge Oakley needs to teach classes on
Let's like to bring up for the record too that
Hold on. Hold on. Have you had a chance to look at what you just handed me? Okay. All right. So are you ready to argue that motion?
Well, no, I had no time to prepare for anything except I've never seen that before. And
Okay.
it's just trying to keep you from being able to bring up all my valid arguments that are all applied to this.
Once again, valid as you determine them,
It's advanced to the case.
as you say.
And that's, and they're the same way with the things they're trying to say, right? They have no evidence. Where's the evidence, right?
Right, but I haven't ruled that anything she's trying to put in front of the jury is invalid.
So my defense to my.
Well, here, let's do it one at a time. She wants to stop you from saying anything about due process violations. Did you plan on telling the jury that your due process rights have been violated?
All part of this case.
Okay.
Same thing with all the traffic stop all the way till now.
Specifically, what were you going to tell them about your due process violations?
Well, I don't have my defense completely in front of me because I'm trying to get all the other matters. I'm not ready for that. So and I've never even seen it, so I can't even build up a defense to that to produce.
How was that provided to Mr. Crisell last week? Okay.
I received his motion, or his $100 motions on Thursday, so it didn't give me much time to respond. I did send it in the mail, I dropped it off at the post office this morning. And I didn't receive his most recent motion.
That was filed Friday. Right.
I said on my certified mail, so I know what you're saying. We've never had first, last name. Never.
All right. So here's what we're going to do. If you decide to participate and present any evidence to the jury today, then if any of these A through E's come up, we'll deal with those as a point on a point by point basis. Understood? I'm not, sir, I'm telling you, you don't have to. She wants me to give you a blanket instruction right now that you can't talk about any of these things that are listed in this motion.
I'm denying.
I'm not going to do that. If you choose to present anything to the jury and one of these topics come up, she's going to stop me probably with an objection, say, Judge, could we talk about that? And then we'll talk about that. Item by item. Understood? All right. Anything else before we bring the jury in? You said you wanted to say something before the jury came in. I thought you said.
Another key point to this, I filed for records requests in court, trying to get all my court hearings and everything in recordings. There's still one from the very first one from Judge Martin that is crucial to this case. They still have issues.
How could it be crucial to the case today?
Second rule in there are absolutely huge to all my rule.
No, they're not. No, they're not.
All of this.
No, sir, everything started on February 3rd, 2024, when your tickets were issued. So anything. Let me answer. I'm trying to be patient, Mr. Crisell. Anything Judge Martin said at a hearing about those tickets after February 24th or February 3rd, 2024 would not affect the facts of what happened on February 3rd. Agreed?
But it affects what is going on with this court as far as the fact that
The only thing that's going on with this jury is deciding what facts took place on February 3rd and how they apply to the ordinances the township is trying to apply.
yeah, then it's going out of that. But again, like I said, I'm not going to subject myself to sitting here through something that I know.
Then get up and leave, Mr. Crisell. You're not under arrest.
Yet.
I've already explained your options. I've tried to be as clear as I can with your options.
Like I said, I will not participate in this. It was clear there's all sorts of stuff going on here that's great against me.
I understand you feel that way, but I've got a trial scheduled today. Something's going to happen. Once again, if you get lucky, they find you not guilty and you're done with this stuff.
Can I take a minute to figure out what I want to do with this?
Absolutely. Oh, one thing I want to make clear. The civil infractions don't go to the jury. You understand that? That's a formal hearing. That's just between us. You understand that? We'll deal with that after the trial if we have a trial today. The misdemeanors will be in front of the jury. You understand that? Okay, take a minute. Make it quick, though. I hate to have the jury wait.
We got a runner?
Mr. Crisell?
Yes.
Mr. Bowditch is available. Doesn't cost you a thing just to get his opinion. All right. Go ahead. Go ahead.
We go with Phoebish. Just.
Yeah, you ready for Phoebish, the plea? Bring him in. You just push record and go.
Okay. I don't know if he comes back. Where are we at on this one?
This
We're up to 4 on the shut your mouth counter. Let's see where. That's not him.
Caitlin, what's the first name? Is this Robin Miller, the complainant?
I think we have a jury panel.
Good morning, Your Honor.
Without him.
Good morning.
For the record, Your Honor, Deputy Bowditch 45367 appearing on behalf of and with Mr. Fee.
Okay, we're gonna skip ahead a little bit. It looks like he took some time. They did some court business. They took a break. That brings us to where we are right now. We're going to jump ahead. Judge comes in, drinking his coffee, as always. Looks like the gavel behind his monitor is in throwing position. The timer has expired.
Hey, try to get him in here, would you?
Try to get him in.
We have our Monday, October 21st for our.
What I'm going to try to do is convince him to do a bench trial, and I'll give him the whole freaking day. He can make all the arguments.
Oh, that's true, yes. So, because I was going to say we can do the other one on that one.
Yeah. So it'll be a special day.
Okay.
It'll be a special day. It'll be a full day of
you know what Jeff's extension is in his office?
1, 2, 3, 4.
Security.
Hey, tell them they don't have to have a final decision. I just want to know if I can send the jury home.
Okay.
You're comment.
This judge likes to stand. He's got a standing desk. I guess it's healthy. A little rough on the feet. He's probably got a nice chair at home. Judge is charging up. I think he stands because if he needs to leap over the bench and throttle a defendant, it's easier from a standing position than from seated.
Hey. Hello.
Hey.
Thanks. That's fine. I got no problem giving you more time to talk, but if I'm letting the jury go, I just want to bring them in so I can talk to them and let them go. You can keep talking. You sure? All right. Bring the jury in.
So I go back here in a minute?
Yeah, keep talking. Keep talking. Hey, Jeff, come here. Mr. Crucell, I'm going to give him an idea to talk about with you.
Okay.
If you listen to the show, I'll give him a whole fucking day for bench trial. He can bring every argument he's got.
There's an F-bomb in there.
All but I will make her sit.
That's what I told him.
But I'm just not doing it with
I said, I wanted him to ask you politely to reserve his right to a bench trial.
Yeah.
And all of his information, he's going to get together.
Just let him know that that's what I wanted you to know.
And
Go tell him that.
I'm not going to represent, but I'm going to help him.
All right. Go tell him that I made that suggestion.
Judge Oakley spent all his chair budget
So,
on a
Caitlin,
4-pot coffee maker.
I gave him an option that if he'll pay the $300 court costs, jury costs, I'll give him an adjourned date so he can perfect all his appeals that he says he wants to file, and we'll send the jury home.
But
What day is
do
that?
you think he's going to pay?
Oh,
He already owes us. Oh, he only owes us the money on these cases.
Yeah, I think he'll pay. Is it hot in here or is it me?
No, it's just you.
It's
But
just you. You're a little heated.
Have a seat, folks. And
There's
Caitlin, you
the
don't have
jury.
to stay for this if you don't want to.
Yeah, you've been here too long already. Jury's coming in. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Got the blue memo. 13, 14, orange jumpsuit.
So you
just
last?
shirt.
Yeah, you got to do the last of them? Right. You love it.
It's a little.
Are we listening to what? I still.
Judge has cowboy boots and Levi's on underneath. I love it. I don't think it's Levi's, but
Yeah, but you guys don't have to do anything.
it's those are dress pants, I think.
No. This guy.
I've never loved the
I've
judge.
seen. Thanks. All right, how many of you got him? They just excited that you can think about being on a jury? One person. You are gonna make them. I'm sending you home. We're gonna pay you for being here, but I think it's $15, so that's part of it. But,
$15 a day.
But I just want to talk to you a little bit about what's going on. So, first of all, I want to thank you for being here, even if I'll be looking bad, you don't really want to be here. But you showed up, okay, you showed up, you're doing your job. So the good news is, well, the good news is you get to go home if you want to. The good news too is that you served your jury duty for this year. You showed up, in fact, we're not putting your work, it's not on you, that's on us. Now, if the federal court sends you a notice, sure, fine, they don't care if you move it. Circuit court downtown, if you get another notice from us, really beautiful. Then just say, hey, I was there on September 23rd today, right? Very nice. Okay, so that's good to be done. If any of you need a piece of paper that shows you're actually here, maybe an employer that wants to make sure you show up where you're supposed to, are we doing that at the kiosk or downstairs?
Downstairs, that's right.
Okay, so then go down to the cashier, just say, I need a letter to show I was here for jury. Other than that, I'll take you out right now unless anybody's got any questions I can answer. Yes, ma'am.
Is there a possibility you will pay your son this week or?
No. Anybody else? All right, once again, sincerely, thank you for showing up today. I hope that this gave you all a free day and you can do something fun. Have a nice day. Thank you. It's not a good day. Sounds like a nap. That's a man around with our.
So we don't know if the defendant's going to take that bench trial advice. The judge wants a bench trial because
With a who?
The camera system. I got to text from someone in the audience. It was great.
It's the camera. It's the camera.
It must be.
the judge wants to do a bench trial because if this guy brings up all sorts of crap that will just confuse the jury, he can set that aside and just rule on the facts of the case.
He's thinking that suggestion. Yeah.
And he's honestly.
And Bowditch has already suggested, what? You don't do a jury trial, this judge will let you talk about anything you want to talk about. Which is what I just called Jeff up to the bench and say, look, I'll give him a whole day. He can make his traveling arguments. So we took Cheyenne's buddy Jessica Radcliffe up today, or this weekend. Because last year she told me what she wanted to learn out. Nah, thank you. So Saturday
Now,
night,
what is open right now? Is it bow?
early ambulance.
Early antlers?
Now I'm talking about hunting.
So
They
basically,
just switch like that. They're
shooting
talking about
does.
Oh, wow. She definitely
She got her first year. She got her first year.
So,
they shot
but it can be
Bambi.
done by gun.
Yeah.
Anything just early, okay, because we were trying to figure that
Yeah,
out.
it's just to try and encourage people to shoot does and get them out of there.
thin the herd.
So do you have to have a doe permit?
Mhm.
Okay.
Anybody can do that?
Well, you got a license.
Yeah.
But the cool thing Michigan did years ago when they actually changed the age, it used to be you had to be 12 years old to hunt, bow hunt, 14 to gun hunt. And then now there's no minimum age, basically. So they do a mentor license. So for example, Jessica can hunt 2 years in a row. With a mentor license, she doesn't even have to take hunter safety. It's kind of like, yeah, let's see if I like this. But she's got to have a licensed hunter with her at all times in the woods. Right? Which is a pretty good deal. You know, you got a buddy, it's like, hey, let's go on next week. Oh, I don't have a license. Or I don't have hunter safety. That's all right. Just go get a bearer's license. I'll take you and we'll go on. I'll have to sit with you.
So then for the 2 years, if you're being mentored for 2 years, does that take the place of hunter safety?
No,
Or still take hunter safety?
before she can get her standalone license, she's going to have her hunter safety. Fine. Which nowadays is all. And then you got to find a field day somewhere where you have to show up any state and stuff. It's pretty cool.
I did my hunter safety when I was
All right, I'm going to
14.
go sign on this.
I think they're done. let's see, where are we? Yeah, I think we're done. The shut your mouth counter ended up at 3. Okay, Josh, that was a winner. You picked a winner. Holy cow! What's the schedule? Can we find on the docket for Mr. Oakley? What happens next? When is the court date? Is it going to be a jury trial or bench trial? I'm not even sure if he's going to show up for it. But it sounded like, believe it or not, Judge Oakley started to get to him and started to say, yeah, I'm on your side. I'm hearing you. I understand. There you've got an argument. There you don't. He's taught him. He's basically, this is law school 101. But good news, Josh did a good job. Bad news, the case is now the expected level. Josh's case is expected to bring back. From now on, Josh, this level or higher is what we're looking for. Just so we've set the bar. Sarah Boone's at 3 p.m. I think it's the last hearing before trial starts. I think so. 3 p.m. for Sarah Boone. That's going to be a fairly quick one, I believe. I think that's all we've got in this one. But man, what a fun case. Holy cow. That Judge Oakley, we've seen Judge Oakley a time or two before. And yes, he does have a bit of a mouth on him. He says what he thinks quite clearly and frequently. Oh, he's live right now. Let's jump back in and see what he's doing right now. It looks like a trial, but it's just hot jump.
And his penis is inside of my leg. He's trying to go inside of your butt. Yes. Okay. And what is it that you use your butt for on like a daily basis? Okay, when you use the bathroom, what would normally come out?
Okay, pause. What is it you use your butt for on a daily basis to go to the bathroom? When you use the bathroom, what normally comes out? Poop. I think we're going to skip that trial right now because I'm just not sure where it's coming from or where it's going. Josh, so apparently not everything Judge Oakley does is suitable for the we're gonna pass on Judge Oakley for just right now. That could be a very bad case or a very sad case. So we're not going to jump there. All right, let's jump back over to Judge Simpson because I showed you just briefly. I showed you we had a defendant who showed up in court who was chowing down. I guess is the best way to put it. Chowing down on some goodies of some sort. Let's see. I want to get back to where he was. We'll start right here. Hang on. Right here. Oh. Start here on 8. There we go. Back to Cedric Simpson's court. I want to see what I brought his picture in
14A District Court, County of
over the other video, but he was in Cedric's court today.
Judge Cedric Simpson preside.
May be seated. Now? How long ago? I did not run into the courtroom. I do not run.
Judge Saunders or
Court, that's not the case. People versus Joseph Thompson.
Good morning, I'm Rob Jacob on behalf of Joseph Thompson. Joseph, would you state your name for the record?
Joseph Thompson, good morning. Good morning, sir.
Judge, today's time of day for pre-trial matter. I met with Mr. Thompson last night. We went over the pros and cons of this assault and battery charge of going to trial. My client is that he wants to stay in court, so we're asking for a jury trial.
That jury final settlement conference will be October 18th, 2024. 9 a.m. jury selection. October 21st, 2024 at 8:30. Both of those are in person. Are you held on something else, sir?
Yes, sir.
Okay. So you're not held. Okay, I did give him a bond so that he's getting credit.
Thank you, Your Honor.
All right.
Jury selection is on the 21st, Your Honor.
Yeah, that and the other 8 cases you set before me, you know that. I'm messing with you, Bob.
Is that at 9 a.m.?
That's at 8:30.
I just have a circuit.
Like you just
trial.
got here.
I have a circuit court trial that day, but I
You
think
do?
Well, I think it's going to work.
No way.
Pardon me?
Nothing.
I'll let the court know.
Thank you, Mr. Gilmore. Thank you, Mr. Thompson.
Thank you.
Court calls the case. People versus Sarah Uda.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Uda, who should be present via Zoom.
I am.
iPhone 99. All right, what do we do? You got a camera, ma'am?
Yes.
Okay, thank you.
You're welcome.
All right, what are we doing?
Thank you, Your Honor. Ms. Uda wishes to set this case for final settlement conference.
Yeah, just join the party. Jury final settlement conference, October 18th, 2024, 9 a.m. Jury selection, October 21st, 2024, 8:30. Both of those proceedings are in person. And we'll continue. Thank you.
Thank you, Your Honor. Thank you, Ms. Uda. You can log off now.
Court calls case People versus Don Lee.
Conrad Solar on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right. Please state your name for the record, sir.
Don Lee. All right. Okay, where are we on this case?
Thank you, Your Honor. This is a driver's license case and I have discussed this with Mr. Lee. He will be accepting the offer extended to plead to MCL 257.326.
So, Your Honor, I'd move to add count 2 of MCL 257.326, allowing an ineligible person to drive. You accept that guilty plea to add count 2. I move to dismiss count 1.
Let's have Mr. Lee's one.
Raise your hand. Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Don Lee.
This court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. You understand that, sir?
Yes, sir.
And understanding all that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand by pleading guilty, you'll not have a trial of any kind, but
Yes.
you cited an advice of rights form, correct?
Yes.
Any question regarding those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's stated here today on the record to get you to plea? Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will? Because you believe that you are indeed guilty?
Yes.
On the date of February 10th, 2024, Michigan Road near Moon Road in Pittsfield Township, Washington County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who is otherwise ineligible to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Anything you want to say before I impose sentence?
Just very briefly, Your Honor, Mr. Lee is asking that the court consider sentencing him to time served. I do acknowledge he wasn't arraigned on this case until September 19th and only has 9 days credit, albeit he was not being held on this case. Outside of that, I just leave it in the court's discretion.
Anything you want to say, Mr. Lee?
And I just wanted to get this over with and keep him going.
You come back on that other thing tomorrow. Is it tomorrow?
He's up on the 8th.
On the 8th.
For exam, Your Honor.
Just trying to recall, when I put you into custody, did we set an exam? Is that what we
Yes,
did
exam is on the 8th.
before me?
No, it's before Judge Burke.
Okay. All right, I'll take a look at that because all right.
I think I have the file up, Aaron. Did the court have a question I could help with?
Well, I put him into custody, but I know I told him I was going to take a look at that on the and into custody on it because it came as a result of a police report regarding something else happening.
Yes, it was because there is a new case that is coming down the pipe, to which Ms. Blanche said that the warrant was going to be authorized that day, I believe. Mr. Lee advises, and I don't see anything to contradict that, he hasn't been arraigned on that new charge yet, however, but the two ones that he was in front of your honor for last week for PCC are set for exam, both cases in front of Judge Burke on October 8th. He's represented by Sam Bernstein in one and the public defenders in the other.
Okay, so my question becomes all right, that's right. That refreshes my memory. Where's that other case? Because the thing, I'm not asking.
Okay.
You don't know.
I know I ain't been arraigned on it.
No, I know, but I'm trying because I don't know. Did I change his bond on? I did change his bond on that. He was supposed to then be arraigned on the other case, but that case was supposed to get. There was supposed to be a timing on that case to get down. So I remanded him. He was going to be held on these cases, on the ones that are set for exam. And then that other case was going to come down, expected that he might be in on that case. But if that case hasn't come down, I'm not going to be very happy right now.
Yes, to my understanding, Your Honor, he has not been arraigned on that new case, but the two cases that are already set for exam in front of Judge Burke, currently his bond is $15,000 on each of those cases.
Correct. I get that. What?
You raised it was a PR bond and you raised it up.
I put it up because of the representation of these other cases, but those other cases were supposed. What's the status of that other case?
Your Honor, Ashley Lottie for the people on behalf of talk about these other matters. So if I'm reading this correctly, other cases was a resisting and obstructing case that was supposed to be coming down. Is that, Ms. Page, is that correct?
I don't think that was, it was involving a car accident and some other stuff.
I don't know the exact charges that were to be authorized, but I know the incident date was before the ones that are currently set for exam.
Right.
That being said, I
know.
Yeah.
Listen, where is that case? Because my problem here is that, and Mr. Lee is certainly not always the most cooperative person in the world, and he knows that. But he got remanded because his other case was coming down.
Correct.
And so I'm trying to, and I think there was a representation that it had been signed off or it was someplace, and the expectation was that case was going to get sworn out. While in custody, he'd be arraigned. And then there would be, based upon the facts of that case, a bond set that was likely or may have, I can't say for sure, may have kept him in custody, which is why I did what I did.
That was my understanding, Your Honor.
I just need a little bit more information.
Go look.
So I want to understand, Mr. Lee was last before the court for PCCs. The court is saying on the 26th or the 18th.
I think it was a week ago, wasn't it? I think it was
the 20th.
I think it was the 26th. He was before me.
I have some help helping right now. So the new case, which does appear to be related to fleeing fleeing and eluding charges. Dated date of incident 8/29/9/20 to 9/2. It appears that case was authorized, signed by my office on 9/26. And I don't see.
That's what was indicated to the court on the record, that it was signed off on 9/26. But then there was a representation that it was going to get sworn to. It was signed off by your office. I think that's what was represented to me. It was going to get sworn to so that Mr. Lee could be arraigned on it.
My understanding is that Magistrate Fink signed that case on September 30th. It is likely,
well, then why hasn't he been arraigned?
I'm not sure, Your Honor. It may be in a stack of things that are waiting to be entered. That's been happening.
Oh,
I don't.
No, that will not happen. Miss.
Can you tell me what the jurisdiction is? Yes. It's not.
It's
not
Ypsilanti
in?
City. It's Ypsilanti City.
It's a city case?
No, I showed us
It's a
14B.
sheriff's office. It's a sheriff's office arrest that occurred in Ypsilanti City.
I show with the 14B.
Okay, so it's on the line. It said the swear out was on the 30th. Yeah.
I have a police officer.
Oh, really?
Yes, that helps.
So, whoa. Is that what the log notes indicate?
Yes,
So there are no charges.
correct. It says court does not find probable cause.
Okay. Okay. Just hold. Hold. That's what it says?
Hold, please.
So there is no case.
Can I confirm the police report number for that?
Yeah, I have it up.
Washtenaw County Sheriff's Department report number 24-67821.
I have 68821. I don't know if that's a typo, but.
And
I'm checking with Melanie.
yes, and while you're checking with them, have me bring them Mr. Lee's other two cases that are set for the 8th. Immediately.
Okay, guys, I'm fighting with YouTube right now.
That's the last one I have. Now.
No.
Okay, let's. Mr. Lee, that's what we're gonna do. I'm gonna have them take you back.
Okay.
And we'll try to figure everything out, have you brought back out, and I'll do what I gotta do.
Okay, thank you.
All right.
Thank you, Your Honor.
All right. I'll see you in person soon.
Okay, thank you, sir.
All right. See ya.
Court does.
Court does what?
I haven't sent to him, right?
You did not.
Okay, I took the plea, but he didn't send him. All right. Court calls case, People versus Billy Pauly.
Ashley on with people.
Kyle Brill on behalf of Mr. Pauly. Good morning, Judge.
I lost my. Is he on Zoom?
I did not have him checked in.
I got it up here. All right, go ahead, counsel.
Your Honor, is Mr. Pauly on Zoom? Simon, I think we're waiting for him to see.
I do not. I gotta click someone. I don't see him on mine.
So
But-
I
well, my only question, hold on, counsel, because I don't know whether he can hear me because my mic's not on here, but.
I only show one unlabeled person.
Okay, we have one person that's unlabeled. There's an individual who is iPhone 1. Can you unmute and state your name? iPhone 1.
Oh, Mustafa Al-Kafaji.
You got it.
Mustafa
Al-Kafaji.
Al-Kafaji.
We got him. Okay, thank you. We'll relabel you. Your client's not on.
Thank you, Your Honor. So, Your Honor, this is a retail fraud case. I was appointed yesterday. I have not had a chance to contact Mr. Pauly. I don't believe I have a good phone number. I'd ask at this time for either an adjournment or a show cause to allow me to write a letter to Pauly and get him to court. This is a fair.
Previous bench warrant, so I'm going to issue a bench warrant for his failure to appear.
Understood, Judge.
Bond will be set in the amount of $5,000. Give a 10% privilege.
Thank you, Your Honor.
That warrant will issue immediately. Thank you. Court does call the case People versus Amy Brewster.
Testimony to the people.
Oh, boy. Here we go.
Ready, Your Honor. Christina Costantino, appearing with and on behalf of Amy Brisley.
I
Amy,
was
could you state your name for the record? Amy
Just now.
Brisley.
Your name, ma'am?
Just here to spice up Wednesday.
I know. All right, what are we doing then?
Your Honor, we've reached a resolution in this matter in which my client will tender a guilty plea to a reduced charge of retail fraud third degree. And there is an understanding that there is restitution owed in the amount of $123.71.
That's correct, Your Honor. The plea will be to an added count to retail fraud from third degree net $500 total amount. Contrary 750-3564. Count one will be dismissed. And I know the court is likely where Ms. Bristol's held on other matters.
It's other things. It's not this stream at all. It's trying to get Sarah Boone working with a live view.
Let's have her sworn.
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Amy Bristol.
It is this court's understanding you're going to plead guilty to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days of jail, up to a $500 fine plus court cost. Fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
Has she signed any advice on this one? Probably not.
Judge, I can have her sign
Pardon?
one.
That's okay.
If you'd like.
Because of that, ma'am, you're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be proven innocent until proven guilty beyond a reasonable doubt. All of that, ma'am?
Yes.
All right. You understand you're giving up your right to appeal, all right?
Yes.
Are you on probation or parole? No. Has anybody promised you anything other than what's been stated here today on the record to get you?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
December 29, 2023, at the location of 4005 Washington Avenue, Pittsfield Township, Washington County, State of Michigan. What'd you do at the mobile station that makes you think that you're guilty?
Your Honor, may I void here?
Sure.
Miss Brisley, on that date, were you at that location in Pittsfield Township?
Yes.
And on that date, did you take some
mobile.
items from that gas station without paying for them?
Yes.
Would you agree that the value of those items was worth $123.71?
Yes.
And no one gave you permission to take those items, correct?
No.
And you passed all points of checkout and left the gas station without paying for those items?
Yes.
The defense would be satisfied, Your Honor.
People satisfied.
Yes, Your Honor. Thank you.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be October 23rd, 2024, 9 a.m. What do you have around now? I added $10.
Yeah, $100.
10%. Okay, we're just holding her then, so she'll get credit. All right.
Thank you. Thank you, Judge. Thank you. Have a good rest of your day.
You do the same. Court does call the case of the People versus Justin Parton.
Actually, on the Pickles.
Good morning, Assistant Public Defender Lauren Parton on behalf of Mr. Parton. Mr. Parton, your name for the record.
Justin Parton.
Your Honor, we have come to the resolution. Mr. Parton is going to plead no contest as charged, and he has been accepted into the mental health treatment court.
Mr. Parton, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Justin Parton.
All right, you can put your hand down. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of retail fraud in the second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
Still wish to plead no contest?
Yes, sir.
Do you know what a no contest plea is?
Yes, sir.
2 things about it, just to make sure that you understand. It means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, sir.
And to that charge, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
Yes, probation.
You understand that this could be considered a violation of your probation?
Yes, sir.
You understand that if it is, that other court could sentence you to the maximum allowable under that charge?
Yes, sir.
Still wish to plead no contest?
Yes, sir.
Anybody promise you anything to get you to plead?
No, sir.
Anybody
No, sir.
threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
Counsel, the basis for the no contest plea in case we didn't understand.
Potential civil liability.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 24174. Any objection to the court having reviewed that report?
None from the people. Thank you, Your Honor.
No, Your Honor.
And you stipulate to the prior conviction.
Yes, Your Honor.
Based upon a review of that report and with the stipulation, the court would, the court would find that there are sufficient facts that would indicate that the defendant has committed the offense of retail fraud in the second degree. Counsel, have I complied with the court?
Yes, Your Honor.
People are satisfied.
Court will accept the defendant's plea to count 1. Defendant's referred to probation for a pre-sentencing investigation and report. Sentencing will be
October 23rd at 9 a.m.
October 23rd, 2024, 9 a.m. All right, Mr. Parton, I need you to wait on the line. We're going to put you into a breakout room with our probation intake so we can get that process started, okay?
Thank you, Your Honor.
Okay.
Your Honor, before you move on to the next case, I would just ask for a signature.
Okay, are you there? Hello?
Yes. Hello, can you hear me?
Yes, who is this?
My name's Amy. I'm calling from the fulfillment department with Ultimate Journey. I have some good news for you.
Oh, hi, Amy. How are you?
I'm good. Thanks for asking.
Good. Did we talk?
It
Did we
looks like-
talk today already?
I didn't talk to you.
Oh, Amy. Okay.
Did somebody else call you?
I forget. I forget a lot of things.
So do I. I forgot what I ate for breakfast yesterday.
Oh, I think I have oatmeal because I have oatmeal every day for breakfast.
Well, that's good for you. Well, because of that, I'm obligated to replace everything with our 2024 package. And as a gift, we are including 4 round-trip airline tickets. Did you want to hear what you have?
For breakfast?
For your travel package, sir.
Oh, I just go into my kitchen. Where can I get breakfast? I'm sorry. Okay. I'm sorry. All right. Gerald is the gentleman who was eating a little snack. We'll see him eat if we haven't already. I'm working right now on the back end here with YouTube, trying to get some things sorted out with my live view because YouTube changed how it interacts with it. Anyway, so we'll continue court, and I'm going to keep working on YouTube. Sorry, that was a short one.
On the memorandum of understanding.
I've signed that as well, Your Honor.
You've been asking me for a lot today.
I'm very needy. I'm sorry.
I'm very needy.
I would say I wish my
Right.
husband would.
She at least admits it.
She's good like that.
The 23rd, thank you.
I am the assigned judge of the transfer.
It's like I've done this a couple times in the process. Every time.
Thank you for everything.
I didn't know we had to do MOUs on in-county transfers, but
I know, yes, I know, but I keep being told that that's what I have to do, so.
and we should probably double check that because I didn't think anything in-county we had to have an MOU. I thought it was any out of county, but it may
Abdallah
be
is looking
because we're
quite festive.
15th
Is he the translator?
and not 14A, maybe?
I don't know. I did not think we had to have that, but pardon? I don't think we've done them for in-county, so we'll figure it out. Court does call the case, People versus Joshua Perkovich.
I should look at the people.
This in the rain? No.
For your honor, Deputy Cass, on behalf of Mr. Joshua Pekovich, please state your name for the record. Joshua Perkovich.
Thank you.
So, on doesn't matter, your honor. Actually, can we approach real quick?
Why?
We got a resolution.
Okay.
Hey, it's my attorney, the guy in gray, the dapper man. Not the dapper Dan, but that's the guy who said, who is that? Hang on, still talking to YouTube. All right. Tell YouTube I said hi. Ashley says hi. Oh, wait, that actually went through. Ashley. Didn't realize my mic was hot to them. They say hi back.
He's gonna plead no contest on this matter, Your Honor.
I'll send the police report, Your Honor.
And for the reasons of civil liability.
When do I get a police report? I can't.
I'm sending it right now. I didn't know this was now.
Let's have him sworn. Has he signed an advice rights form?
Not yet.
Man, I think Abdallah needs a few more stars and stripes in his window. Lisa, it's supposed to be 107. Oh my goodness. I think it's like 65 outside today. Gerald is just chilling in the break room. It's on his lunch break. He's hungry. He's almost becoming hangry as he waits for court.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Joshua Perkovich.
Sir, it is this court's understanding you're going to plead no contest to the charge of assault and or assault and battery. Is that correct?
Yes, Your Honor.
That is a misdemeanor punishable by up to 92 jail, $500 plus court costs. You understand that?
Yes, Your Honor.
Do you understand what a no contest is?
Yes.
Things about it, I need to be sure that you understand it. First of all, mean that you're not desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis for the no contest plea?
Civil liability, Your Honor.
All right. So to that charge, how do you plead, sir?
No contest, Your Honor.
Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
All right. You had signed an advice of rights form today. Do you have any questions regarding any of those rights?
I do not, Your Honor.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor. Probation.
Were you on probation at the time of this offense?
Yes, Your Honor.
You understand that this could be a violation of that probation?
Yes, Your Honor.
You understand that if it is considered as such, that you could be sentenced to the maximum term under the other charges. You understand that? You understand that, sir?
Yes, Your Honor.
And understanding that you still wish to plead guilty to this charge? You do?
Plead no contest, Your Honor.
Well, plead no contest to this charge. You still wish to do that?
Yes, Your Honor.
Are you on probation or parole? Well, you're on. Has anybody promised you anything other than what's been stated here today on the record?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Yes.
And because you, well, I won't ask that. Court has been provided and is reviewing Washington County Sheriff's Office report for their case number 24-59269. Any objection to the court reviewing that report?
No, Your Honor. Thank you.
Your Honor. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yeah, Your Honor.
People are satisfied. Thank you very much.
Court will accept the defendant's plea of guilty to this charge. Defendant is, victim's right. Defendant is referred to probation. Sentence investigation and report. Sentencing in this matter will be October 23rd, 2024, 9 a.m. Bond will continue.
Thank you, Your Honor.
To bond, Your Honor. Is he still on PR bond? To my understanding, that's what
He is on this case. You want that change?
No, I do not want that change, Your Honor.
Well, he's not getting credit on this case. That's my. What else are you held on, sir?
I'm sentenced on my other charge, Your Honor. I just was sentenced to treatment, but due to my injury, I'm not able to go to treatment right now.
So you're just sitting,
So
waiting.
my attorney's in the motion of getting me released either this week or next week to do outpatient versus inpatient, so I can attend to my knee injury.
Well, what I'll do in this case, I'll just leave it at a PR so that doesn't get interfered with. Okay, thank you.
Thank you, Your Honor. I'll be in touch.
Court does call these other people versus Denata Rekovic.
I think that Swahili guy is the interpreter. I've seen him before. He's got a very fancy layout.
Assistant Public Defender Natalie Pay on behalf of, but not with, Ms. Rekovic. Your Honor, our office did receive some documentation that she is currently hospitalized. I just emailed that to the court a few moments ago. To my understanding, her CMH worker reached out to us, and she's hospitalized at Stone Crest.
Abdullah is
So I would
in,
respectfully request an adjournment.
Evil Knievel's
doesn't
green room.
indicate how long, but
Oh, Your Honor, I did not see that on there either.
November 6th.
Yes.
I'll adjourn this matter November 6th, 2024, 9 a.m.
Thank you, Your Honor.
Thank you. Court calls case People versus Amanda Reese.
Actually, one for people.
She and back.
There's, I think,
Amanda Reese.
Assistant Public Defender Natalie Pay on behalf and with Ms. Reese, who is approaching the podium. Please state your name for the record, ma'am.
Amanda Reese.
Gerald's not in a good
Thank you, Your Honor. Ms. Reese is requesting that I do some further investigation into this matter. She is not being held on this case. So we are respectfully asking a 3 to 4 week adjournment.
and you're not opposed. Of course, there is an offer to an added count of retail fraud in the third degree to resolve the case. I understand that the defendant, the last time we were here, had an active warrant in 14-1 and in 14-E. It looks like she did surrender.
That is correct, Your Honor. I have discussed that offer with my client. She would like me to do some further investigation first.
November 6th, 2024, 9 a.m.
Thank you, Your Honor.
Court does call the case People versus Samantha
Samarasinha.
Whoa.
Samarasinha.
Exactly,
Yeah.
exactly what I said.
Holy
All right. Thank you, ma'am. Can you
She's coming in hot.
Can you turn on the camera, please?
Yeah.
Yeah, there you are. Okay, thank you.
Good morning, this is Public Defender Lauren Kearney on behalf of
See her
Ms.
silhouette.
Garcia. And I think we're going to come to a resolution. I just want an adjournment so I can explain the possible penalties to Ms. Garcia again.
Gerald,
hang in there, man. Hang in there, buddy.
October 16th, 2024, 9 a.m. Or as you're invited, Gates Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case People versus Matthew Scott.
After a lot of people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Scott. Mr. Scott, please state your name for the record.
Matthew Scott.
And Your Honor, we have come to resolution. Mr. Scott is going to be pleading.
Hang on. These went to counsel.
Matthew Scott has good horizontal view, fills the frame nicely, good positioning. We can see him a little blurry, but the lighting's better than the last one.
The court's referring to the emails I believe we did at the last pretrial.
That's wrong.
Okay. Go ahead.
Mr. Scott is going to be pleading guilty to an added count 2 of operating while visibly impaired in exchange for a dismissal of count 1.
And that is correct, Your Honor. Operating while visibly impaired. First offense is a 9-degree misdemeanor, $300 fine, 4 points, and other license violations to Secretary of State 2576253A.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name for the record.
Matthew Scott.
All right. You can put your hand down. Sir, it is this court's understanding you are going to plead guilty to the charge of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days jail, $500 or $300 fine plus court costs. The court could order any rehabilitative service or community service the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you, and you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Gerald smells
Of
some
your
bits of
own
lunch
free
cooking.
will?
Yes, sir.
And because you believe that you're indeed guilty of this offense?
Yes, sir.
December 23rd, 2023, Hawks Avenue, Pittsfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, you consumed intoxicating liquor?
Yes, sir.
What'd you have and how much?
I had shots and I smoked marijuana.
Oh.
Were you stopped by the police or was there an accident?
There was an accident.
Shots are whiskey, right?
What happened?
Or tequila. Do you do shots of either?
Consumed shots in THC, drove and got into an accident and then was later taken to the
Okay,
hospital.
I understand you got into an accident. What happened with regard to the accident? What'd you hit?
Another motor vehicle.
More detail.
Did the police arrive?
Yes, sir.
Were you ultimately arrested?
Yes, and then taken to the hospital where they took my blood test.
And?
All right. And what were the results of that blood test?
0.057 alcohol and 16 ng per milliliter of blood for the marijuana.
Do you have any reason to dispute those test results?
No, sir.
Taking everything into account on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol and ingestion of marijuana?
Yes, sir.
Counsel, have I complied with the code?
People are satisfied and will note for the record that 16 nanograms was Delta 9 THC, the active metabolite, just to make it clear, it was not a carboxy.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel.
He was not
Sentencing in this matter will
impaired
be
with alcohol, at least beyond the legal
October
limit.
23rd, 2024, 9 a.m.
I'm sorry. I couldn't hear the date again. Could I get that again?
October 23rd, 2024, 9 a.m. or as your invite indicates.
Yes, sir. Thank you.
All right. Thank you.
I did want to discuss one more thing.
course you
Mr.
do.
Scott has a medical marijuana card. Community Corrections wanted to get the court's approval for him to use medical marijuana.
Not at this time.
Okay, thank you.
I'm not going to speak to that issue. We'll have to get an assessment on him regarding that.
Okay.
Sir, I need you to hold on line. We're going to put you to a breakout room with probation intake. They'll give you further instructions to get the process started. Thank you.
Yes, sir.
Court does call the case. People versus John Smith III.
Assistant Public Defender Natalie, on behalf of Mr. John Smith III, who I do not believe is present unless he has made his way onto the Zoom.
They're not checked in.
Your Honor, yeah, the number I had for him was no longer connected, and I did send him an email. I did not hear back. For the record, I'd ask for an adjournment.
Bench warrant will issue for defendant's failure to appear, bond 5,000, 10%. I will not have that warrant issue until
Gerald's trying to be polite, but he's hangry. He's waited a long time. And
I know you didn't hear me. You never listen. October 4th, 2024. Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Tomco.
Assistant Public Defender Natalie Tate with and on behalf of Mr. Tomco, who should be present via Zoom. Sir, could you unmute and state your name for the record?
Craig Tomco.
And Your Honor, I do believe we have reached a resolution in this matter. The people have offered plea to an count 2 of retail fraud in the 3rd degree, 93 misdemeanor, $500 fine or trouble amount, contrary to 750356E4. In exchange for a plea to that count 1 will be dismissed.
That is correct, Your Honor, and I have discussed that with Mr. Tomco, and he wishes to accept that offer today, pleading no contest.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name again for the record, please.
Craig Tomco.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud 3rd degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the rated value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, sir.
All right. Still wish to plead guilty?
No contest.
Or no contest, I'm sorry. You still wish to plead no contest?
Yes.
All right.
Yes, sir.
You do understand what a no contest plea is?
I do.
I'm sorry, I didn't hear your response, sir.
I do.
All right.
I now pronounce you man and white. Oh, wait, wrong.
2 things about a no contest plea I need to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty to the charge. You understand that?
Yes, sir.
Basis for the no contest plea.
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest, sir.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
I do.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Yes.
Were you on probation at the time of this offense in 2022?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case 22-1072. Any objections to the court having reviewed that report?
No, Your Honor.
Any objection from the people?
There is no objection from the people. Thank you, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation.
I have to let you in on this. Hang on one second. Ready?
for a pre-sentence investigation and
We'll
report.
let him finish this, and I'm going to tell you what's
Sentencing
happening
in
with
this matter will be October 23rd, 2024, 9 a.m. or as your invite indicates. Bond will continue. Sir, you need to wait on the line. We're going to put you into a breakout room with probation intake to get this taken care of.
Okay, before the court calls the case, let me show this really quick. So I'm having a YouTube issue that there's an error message that it's not interacting with my live view the way it's supposed to, which is a problem because Sarah Boone's coming up next week. So I walk through, I give them all the information. I'm texting back and forth with my live support, 24/7 live support. And they say, give me your channel ID, everything. I give them all the information. They're like, what's the problem? Let me put it on hold for 3 to 5 minutes. Thanks for patiently waiting. Upon checking your channel, it doesn't appear the Google account you're signed into is linked to your YouTube channel you want to discuss. To protect, and I'm like, oh, oops, that was my fault. I go to change and I wait. I say, hang on. I show I'm logged in to my proper email. That's the owner of this channel. Response from YouTube: I understand that. You can contact us back. Anything else? I said, yes, I would be contacting you using this same account. I am logged in as the owner. I started this chat logged in as the channel owner. All right, then. Thank you for contacting us. Have a great day. Thank you for contacting YouTube. Have a great day. This chat ended. I have a one-on-one scheduled with YouTube Manager next week, and it's driving me nuts. Oh, my goodness. So, anyway, AI is not taking everyone's job. There are some jobs it won't take. And that's one of them, apparently. At least it won't do it well. Okay, let's go back and finish Judge Simpson.
Understood.
Because Gerald is dying to get his day in court.
All right, thank you. Bond continued. Court calls
I'm gonna
case
contact
People
YouTube
versus
again.
Karen Zakis.
Ashley Lonnie for the people. Alexis Earps on behalf of Ms. Zekas. Can you please unmute and state your name for the record, ma'am?
Good morning, Karen Zekas.
Your Honor, we'd just be requesting an adjournment. The people have indicated we should be receiving some video discovery, hopefully this week, and then I would like to review that with Ms. Zekas.
That's correct, Your Honor.
October 16th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
This is the rest of Mr. Lee's information.
Let's get him out.
This is the one that was denied. So it was not authorized. I printed it because it was sent to me, but it was not
That's right.
authorized. Yeah, and then those are the prelims. Yes.
If I get the same agent, if it's Cindy again, I'm going to flip.
Ms. Zakis, did she hear me? Ms. Zakis, you're good. You're muted.
Am I all set?
Yes, ma'am.
Thank you so much. Have a nice day.
You too.
Bye.
Court recalls case People versus Donnelly.
Sure, is the court calling the felony matters or just?
I am calling the felony matters also.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right. Please state your name again for the record, sir.
And I'm calling so that we're clear, 24 FB 1322, as well as 224 F 1261.
It was 1322 and 24F2 1261.
The felony matters, yes, ma'am.
Thank you, Your Honor. Ashley Lonnie for the people in both of those matters.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right.
I still have to sentence him on the driving well or the operating well. So we've taken a look at it, that complaint that I put Mr. custody on it was not, there was no probable cause found. And so that was not done. And I'm going to say this. They knew the reason. Mr. Lee understood what I was doing and putting me into custody. The prosecutor's office, I think, was under, given the representation made to this court, was under an obligation to contact this court immediately upon notification that those charges were not brought, knowing that that affected Mr. Lee's liberty. And I'm not happy that I wasn't contacted at all. Anything you want to say before I set him on his misdemeanor?
Nothing further, Your Honor. I would just reiterate his request be sentenced to time served on that misdemeanor.
Fines and costs of $250. Those fines and costs are waived in their entirety. 90 days suspended on that case. With reference to his felony matters, those will continue to preliminary examination on October 8th before Judge Burke. Bond on those cases, both will be set at personal recovery. The conditions will remain. They never left. It's just they took his liberty on something that didn't get authorized. You're going to be free to go.
I'm going home today.
You're going to be let out, sir.
Thank you.
Thank you very much, Your Honor.
Court's going to stand in recess.
All right. Thank you, Your Honor.
You're welcome.
Look at Gerald. Gerald's like, wait, what? What? For my chopped liver? Do you see his head shake when he said the court's going to stand in recess? Oh, Gerald is ticked. Okay, I'm now talking with Cloud, my YouTube support agent, Cloud. And I said, please tell me I'm talking to a real person and not an AI bot. The last bot hung up on me, completely disregarding my comments. Yes, you're chatting to a live person. Thanks for reaching out. I hope you're doing well. I really appreciate that you reached out to us. And I explained the problem. Then they reply, how can I help you today? Yes, we go to the process that will work on authorized account. So that was like a real person. I explained the problem in fully again. Then this is back to back messages. Thanks for the information. I really appreciate that you reached out to us. Thanks for reaching out. I hope you're doing well. I certainly understand how you feel right now. I know how important this is to you as a creator. Let me help you check on this. Kindly give me 3 to 5 minutes to check on my resources. Please stay connected. Thanks for patiently waiting. Let me share some information here. This is like beep, 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 beep. It's faster than people can type. Okay. He's hitting all the buttons for the macros. Oh my goodness. Oh man, he's got a fuel. Is that a NOS? I think he's drinking a NOS. He's got an energy drink. Gerald is upset. He's like, I've been sitting here forever. Oh, he's pounding it, tips it back, drains half the can. He's like, yeah, now I'm feeling the energy. Now I'm ready to do something strong and manly. Like what? Wait for court. After all that. To help make YouTube safer for everyone, we limit how many live streams a channel can create in a 24-hour period. Kindly visit this article to learn more. I hope this helps clarify your concern. Is there anything else I can help you with? I reply, I already read that article. What is the limit? And how can you raise my limits? Okay, we can fast forward through this. Oh, wait. He's eating. They're texting. Oh my goodness. Every time it beeps, my anger level rises like a notch. I have a daily limit on how many live streams I can create. I use the Top Mark Media channel to create a live stream with the live view, and I got the error on the second attempt. I then tried to use the Recovery Addict channel, and I got the error on the first attempt. And all they say is that there is a daily limit to how many streams you can create. And I said, please tell me what the limit is. But there is no information on that here. But if you have reached the daily limit, you will not be able to live stream again. Have I covered everything that's important to you? Gerald is starving. I feel Gerald's pain right now. The anxiety, having just had a NOS 5, and waiting for court. But the judge leaves you hanging. You've been sitting there for a whole block, nothing happening. Let's see, Gerald, where are you at? Let's do a little check. Oh, let's see if Gerald comes back here. There, Gerald's back. He's got the whole loaf of bread, the whole loaf. Here we go. Let's tear into that. Is that a tattoo sleeve? It looks like he's covered his whole arm in tattoo. Like inked his entire arm, not a single picture. Or is that a shirt? Nom, 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 nom. I feel very involved in Gerald's lunch right now. Just plain pita. Just having pita. This guy is in Judge Simpson's court, waiting for his day in court. Very frustrated that it has not come already. No hummus, no dip, no salsa. If you're just going to eat a straight pita, throw it on a flat griddle, cook it up till it's almost a chip. Make a chip out of it, and then dip it. It's delicious. You can live stream tomorrow. I hope you understand that. If some problem persists, contact us again. We'll be happy to assist you. Is there anything else for today? I can't wait to talk to a real person. My YouTube account manager meeting is next week. Worse than the dentist. All right. How many stream keys do you have? Gerald, finish your food. Don't leave it hanging halfway out of your mouth.
I have 2 updates. Well, one is a good one.
Jesus, I gotta swear an interpreter.
This
Gerald's like, now what's happening?
that's a license. Yeah.
Did he say this is BS? Now he's glaring at us.
All right. The 14th District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Jay said attempts to preside.
Has the state prosecutor left?
I think so.
She needs to get back in here because I'm going back on the record on Mr. Lee. I don't know who else has that case. You may be seated, folks. Yes.
Uh-oh.
At 1 o'clock?
Yeah,
I want her here because I need a message gotten to that office right away.
Prosecutor, okay, stop, pause. 2 things. We're going to rewind about 2 minutes. Let's see where we're at. We're at 5:05:34. Let's do a quick rewind. Zip. Num 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 num. Gerbil, 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 gerbil. You guys said he said something. Oh, right here. Here we go. I think this is it. Watch his mouth. Let's see if we can lip read. I don't know. I don't know what it was. I'm not sure what it was, but he's big mad. Oh, that was an F-bomb. We'll get the mad judge one more time here.
That's a good part about it. I have 2 updates. Well, one is a good one.
Jesus, I gotta swear an interpreter.
This
You better hope he's muted.
that's a license. Yeah.
Gerald's frozen right then. Okay, we're gonna skip forward.
All right.
All right.
The 14th District Court for County of Washington, State of Michigan is now back in session. The The Honorable Judge Jay said attempt to preside.
Has the state prosecutor left?
I think so.
She needs to get back in here because I'm going back on the record on Mr. Lee. I don't know who else has that case. You may be seated, folks.
Gerald's really upset that he got. Judge was in a good mood. Now Judge is in a bad mood, and Gerald
At 1 o'clock. I want her here because I need a message to that office right away.
Mean mugging with a pita.
Court does call the case People versus Kevin Serta.
Conrad Stiller on behalf of Pittsfield Township.
On behalf of Mr. Serta, with pushing witness stands to my right. Mr. Serta, please introduce yourself to the judge.
Kevin Serta.
Thank you.
Your Honor, thank you. I was recently appointed to this matter. Mr. Serta and I have not had a chance to have a formal discussion to prepare for this case. We're just asking for a brief adjournment.
Gerald will be back. I think they
October
banned him.
16th, 2024.
I could just
9 a.m. or as you're invited.
The court shut off the feed because he was eating.
Bond continued.
Thank you, Judge.
Court calls case of the People versus Irina Castillo.
Conrad Stiller on behalf of Pittsfield
Gerald's
Township.
back.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Castello.
Ms. Castillo, you need to unmute.
Hello.
Whatever you do, Gerald.
Castillo, do you have a
When's
camera?
it my turn?
I'm in a public place. I'm at a store.
Well, Your Honor, while she's figuring out her camera, I will say that I'm asking for an adjournment. The videos that I received from Mr. Stiller, I have to have my IT folks look into.
I'll adjourn October 16th, 2024, 9 a.m. and you'll let your client know that I don't care where she is, she needs to have a camera next time. Bond continued.
Yes.
Court calls the case People versus Dion Chapman.
Conrad Stiller on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Chapman. Chapman, please state your name for the record.
Dion. Chapman.
Dion Chapman.
Need a camera? Thank you. What are we doing?
You know, we are asking for an adjournment. Mr. Chapman is trying to get his license, but has alcohol assessment. He thought he was gonna have it done by now, but didn't have it's a couple $100s to do it. So
November 6th,
thank you.
9 a.m. Bond continued. Court is recalling the cases of the People versus Don Lee, both as felonies and as misdemeanor cases.
Good morning again, Your Honor. Shalani for the People.
Assistant Public Defender Natalie Pay on behalf of Mr. Lee.
I'm going to waive Mr. Lee's appearance because they took him down so he could be processed out immediately. But I want to make a record clear and know, and I realize, Ms. Lundy, you were not the one involved, but I am more than livid right now because this case, we went back and checked our records. Mr. Lee was taken into custody on the People's representation regarding the previous case. I took him into custody at 11:43 a.m. on June 26th. After having him wait here in court, I took him into custody on that date, and it's important, at 11:43 a.m. on the 26th. There was an attempt to swear out that case that was done before Magistrate Fink less than an hour later at 12:31 p.m., where the magistrate did not find probable cause. And this court was not informed. Mr. Lee was in custody. It was another attempt made to swear out that complaint on the 30th. Again, no probable cause. It is inexcusable that the prosecutor on their representations had this court act that deprived Mr. Lee of his liberty for 7 days. Inexcusable. So, Ms. Lonnie, again, while you are not the person that was involved in this, but has done, I will expect a call from Ms. Burton Harris regarding this matter.
Yes, Your Honor.
Today.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Whoa, looking out for the rights of the defendant. That's bad.
Court does call the case of the People versus Daryl Jarrell.
Gerald is like, ugh. You don't want to be next, Gerald. Trust me. Let the judge cool.
Your Honor, Daryl.
The last person I expected to see.
I thought I was your favorite. We got high ratings.
What?
I thought I was your favorite. We got high ratings.
High ratings? Okay, well.
Yeah, on YouTube.
How are you doing?
I'm good. How are you?
Okay. What we can say is we've learned something from all of this, haven't we? All right. Let me ask you this before we go on. You had something to eat?
I have.
Okay, good. Okay. All right. All right.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Jarrell. Mr. Jarrell would like to set both matters for final settlement conference.
Okay. Hopefully we can find a way to get these things resolved.
This was the contempt guy, I think.
So jury final settlement conference. So you're going to have 2 days, Mr. Durrell. Will be October 18th, 2024 at 9 a.m. Jury selection on these matters, if necessary, will be October 21st, that Monday at 8:30. Got it?
Gerald is not impressed.
Pardon? I got it.
So she's going to write it down for me.
Okay.
Because my hands are cuffed behind my back. What?
Did you, I know the last time you were here, you didn't have a phone or anything. You got?
No, sir.
You still don't?
Still don't. And then the other one would be the 20th, you said?
No. You got the 18th. That's going to be a Friday.
At 9 a.m.
At 9 a.m. And then if it proceeds past that point and we have to select a jury, it'll be on Monday, that following Monday at 8:30.
At 8:30. Thank you.
I think Gerald right now could screenshot his screen and just be a
This has
meme.
made my day. I really did not expect to see you.
Why not?
Well, because you had a date on the 4th.
Yes.
And you weren't here. And I said, I don't know if you remember everything you said to me on the first, or said in court on the first day.
Yeah.
And I thought for sure that he didn't appear on the 4th. And I said, Jarrell is gone. He's just going to disappear.
No, I came on Labor Day. What happened? I come on Labor Day and the court was closed. I'm like, what? This isn't right. Something's going on. And then I was here this morning at 9 as well.
Were you? Okay. All right. So make sure what you might want to do, well, those dates we don't have them in block. So if he gets here in the morning, he's good. Right. Okay. All right. You're set. Take care. Have a good one. Court calls the case. People versus Gerald Cicciotti.
Gerald, you're up. Gerald, this is you. Don't screw this up, Gerald.
Good morning, Your Honor. Alexis Zerps on behalf of Mr. Cicciotti. We have reached a resolution in this matter. Mr. Cicciotti will be admitting responsibility to double parking.
That is correct, Your Honor. So I move to add count 2 of double parking. If you accept that admission, move to dismiss.
The infamous double parking.
Is that a correct statement, sir? Is that what you want to do?
Yes, sir.
He's been here all morning for double parking.
And you admit responsibility to double parking a motor vehicle in Pittsfield Township on July 20th, 2024.
Yes, sir.
On Carpenter Road. All right. Court will accept that admission. Fines and costs of $180. When can you get that paid?
If you could give me a couple days, I'm at work right now.
And they're about to fire
You need a couple days?
Because
I don't usually get that.
Tomorrow
So
or later on.
No, just pay it by the 18th of October. How's that?
All right. Thank you. Thank you. That sounds great.
All right. Thank you, sir. Have a good one.
Thank you, Your Honor.
Yeah, you too.
Okay, so what is it?
Court calls the case. People versus.
They dropped it from something else. What's the
Daria
charge they
Davis.
dropped it from? Can somebody find out? Gerald Cicciotti.
Assistant Public Defender Lauren Perny on behalf of Ms. Davis. Ms. Davis, can you state your name for the record, please?
Daria Davis.
Thank you.
Your Honor, we are asking for an adjournment of both free trials. Ms. Davis is working on getting her license.
Is that correct?
Yes.
When you get it, you gonna be able to drive? Never mind. Don't answer that. No, November 6th, 2024, 9 a.m. All right. Thank you, ma'am.
Thank you.
Court calls case People versus Ashley Dishman.
Henry Sewell on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Dishman. Ms. Dishman, cue and mute and state your name for the record, please.
Ashley Dishman.
All right. What are we doing?
It's
Your Honor,
just
we
Zoom.
have come to
It's just
resolution.
Zoom.
Ms. Dishman is going to be pleading no contest as charged under is deferred.
That's correct, Your Honor, if she is approved for a deferred sentence.
Okay, I did. All right, ma'am, please raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name again for the record.
Ashley Dishman.
All right, Ms. Dishman, it's this court's understanding you're going to plead no contest to the charge of retail fraud under the Pittsfield Township Ordinance. That's a misdemeanor punishable by up to 90 days in jail and a $500 fine plus court costs. You understand that?
I do.
Still wish to plead no contest?
I do.
Do you know what a no contest plea is?
Yes, sir. She explained it to me.
Two things about a no contest plea I have to make sure that you understand is the first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
Second thing is that for the purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I do.
All right. Basis for the no contest plea?
Lack of recollection.
So to that charge, ma'am, how do you plead?
No contest.
Now, you
She got it
understand that
right.
by pleading no contest, you'll not have a trial of any kind.
I do.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten
What are
you
we
or
hearing?
coerce you?
No, sir.
Is that Mickey Mouse?
You're doing this voluntarily
I am.
and of your own free will.
I am.
The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 24-5627. Any objection to the court having reviewed that report?
Oh, none for the people.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Excuse me, court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report and consideration of prosecutor's deferred sentencing. Sentencing in this matter will be October 23rd, 2024, 9 a.m. or as your invite indicates, bond continued. Ma'am, please wait on the line. We're going to put you into a breakout room with our probation intake so they can start the process.
Okay, thank you.
Thank you. Court calls the case, People versus Sharon Fincher.
Honor, it's still on behalf.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Fincher. Ms. Fincher has a valid license and is given me permission responsibility to double parking on her behalf.
That
So
is
driving
correct,
without a
Your
valid
Honor.
license,
Count
they
two of double
reduced to double
If you accept
parking.
that admission, move to dismiss count one.
Boone's
And
in
you
an
do
hour,
so
I think.
admit on her behalf to double parking on the date and time in question.
I do.
Court will accept that admission. Fines and costs of $180. When can she pay that?
She's asking for 4 weeks.
When would you tell her?
Well, she wanted more, so I told her I'd ask for 4 weeks.
Fair enough.
I'm learning.
Yeah, you are. In a slow process, but you're learning. No. Tell her. I'll give her till November 27th, 2024. Just tell her if somebody says Happy Thanksgiving, she's late paying us. All right. Court calls the case, People versus Jesse Hamlin.
Honor, it's still on behalf of Pittsfield Township.
Public Defender Natalie Pate with and on behalf of Mr. Holloman, who's to my right. Please state your name for the record, sir.
Jesse Holloman. Thank you.
Thank you, Your Honor. There is a resolution in this matter to which Mr. Holloman will be pleading no contest to an added count 3 of operating while visibly impaired in case number 0412396. And in exchange, counts 1 and 2 will be dismissed. And the case 2410954 would be dismissed entirety after a successful plea.
That is correct, Your Honor. So I move that count 3 in case 2396. You accept that guilty plea to the added count 3, dismiss counts 1 and 2 in that case, as well as case 0954 in its entirety.
Chapman sworn. Basis for the no contest plea.
No contest.
Lack of recollection.
Let's have it sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Jesse Holloman. Sir, it is this court's understanding you're going to plead no contest to the charge of operating while visibly intoxicated.
Yes.
That's a misdemeanor punishable by up to 93 days in jail, $300 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor.
All right. And understanding that, you still wish to plead no contest?
Yes, Your Honor.
Do you understand what a no contest plea is? Okay, 2 things about a no contest plea I need to make sure that you understand. The first thing is that it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
Has he signed an advice rights form?
Yes, Your Honor.
Now, understanding all of that, how do you plead to that charge?
No contest.
That you understand that by pleading no contest, you will not have a trial of any kind, sir.
Yes, sir.
All right. You signed an advice of rights form, correct?
Yes, Your Honor.
Any questions regarding those rights?
No.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 047506. Any objections to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court would find that there is a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor. Excuse me.
Court will accept the defendant's plea to count 3.
We're coming up on a break here.
In that case, 2396 counts 1 and 2 are dismissed, as well as the accompanying case ending in 0954. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be October 23rd, 2024, 9 a.m. Okay, bond in this matter will continue. Thank you, sir.
All right, we're going to mute the audio here, just check and see what happens coming up. We have nothing interesting for just a wee bit. Wait, hang on. Carolyn Hoskins comes on. Let's see, is there anybody else? Why is it not going quickly? Oh, yes, right here, right here. Hang on. There we go.
Public Defender Natalie Pate. On behalf of Mr. Kafaji, sir, can you please state your name for the record?
He's in the club.
Mustafa Kafaji.
What are we doing?
Thank you, Your Honor. I'm asking for an adjournment in this case. Your Honor, I believe this may have been my error. So Mr. Kufaji has 2 open files in front of Your Honor. He did fail to appear, I believe it was in August due to a Zoom issue. He filled out the bench warrant recall form for one case. That is the case that is on Your Honor's docket today. but I believe he still may be in bench warrant status on case 2410768. That is not on the docket today. So for this case, we'd be asking for an adjournment so he could get an appointment with the Secretary of State to work on his license.
November 6, 2024, 9 a.m. Submit another bench warrant request for him so we can have that one set.
Thank you very much, Your Honor. Thank you, sir. You can log off now.
Appreciate your honor. You have a wonderful day.
Thank you. You take care. Court calls case, People versus Jesse Keisha.
Still on behalf of Pittsfield Township.
Good morning, this is the Public Defender. Mr. Kisa, can you mute and state your name for the record, please?
Jesse Eason. Thank you.
Your Honor, we're asking for an adjournment of this trial. Mr. Kisa has a case keeping him suspended, but he's scheduled. Wait.
I did offer double parking.
Oh, well, I just noticed. I'm sorry, Your Honor. So, Mr. Kisa, if I may.
Side.
Can I stop you?
I mean, you could definitely.
Yeah, I could, but go ahead.
So, Mr. Kisa, the prosecutor has extended an offer to dismiss the misdemeanor if you admit responsibility to a simple infraction called double parking. Doesn't go on your driving record, doesn't go on your criminal record. It's a fine of $180. And that means this case would be over and you just have to deal with your other case.
Okay. Yeah,
Is that what you want?
Yeah, that would work. Yeah.
Yes, sir.
You want to do that?
Yes, sir. That would work.
So, Your Honor, I move that count 2 of double parking. If you accept that admission, I move to dismiss the misdemeanor charge.
And sir?
Okay, so he's going to get the double parking spiel and admit that he was double parking. Why is the jog going so slowly? Then we've got a Swahili translator. Just trying to get caught up. Now we're caught. Now we have a break. I think we're going to take a break right now as well. Just this is what's coming. Oh, we've got. Oh, look at this. Hang on. Back up. Where's a good picture? Right here. Top right. Lindsay Allen is sitting in car wearing a shirt that says "Buckle up," not wearing a seatbelt. And you got Derek Jones doing the peek over the fence from the what is it? The Tim Allen video. We've got some good stuff coming up. We'll watch this right after the break. This just barely happened, so we'll hold tight right here. All right, we're gonna have a break. We're gonna take a quick lunch. I've got breaking news out of Las Vegas. The Robert Tellis trial. That's the gentleman that did everything on camera. Short guy, bald politician, whacked the reporter who did a hit piece on him. Defendants reply to opposition to motion to clarify and supplement the record comes out of the defendant Robert Tellis by and through counsel and hereby submits this reply to opposition to motion to clarify and supplement the record for an evidentiary hearing dated this day, September. That was in September, and the response on this one was, let's see. An evidentiary hearing was denied for the Robert Tellis trial. Tellis is set for 10/16 at 8:30 a.m. Sentencing on the murder with use of a deadly weapon on a victim 60 years of age or over. So the evidentiary hearing is denied. We'll move forward with sentencing in 2 weeks. 2 weeks on that one. All right. Home Improvement. I think it is Home Improvement. Is that the guy that peeks over the fence? So you just see his eyes, like you just see like right here. That's him. How long are we going to lunch for? It's got to be short because we got to get caught up. Can you give us half an hour to 45 minutes? Because we also have Sarah Boone that starts in 55 minutes, so we have to be back for that as well. Mr. Wilson, it's Wilson. That's his name. All right. What happened to the weed and speed trial? Please, we had the verdict this morning. Lisa, do you want me to spoil it for you? We played it here on the live stream first thing this morning. Ashley says, read my comment. Are you going to cover the Brian Walsh case in MA? A hearing for it. Tell me again what he did. Is this like channel friendly? I know Brian Walsh is like a name I should know off the top of my head, but my brain is full right now. It's full of YouTube argument. Can you go live again before you end? Oh, Doodles, you're talking about... yes, I understand what you're saying. He offed his wife. Oh, is he the one that the body was never found, right? Give me just 1 second. We're going to create afternoon. It's going to be... reuse settings. Oh, not that one. Refresh. Sarah Boone hearing. With only one B in Boone. Baboon. That would be, no, that's something else. Sarah Boone hearing and court watch. Okay, we'll go live here. Let me just check the details. Customization. No reactions. And we'll go live in 45 minutes. 12:45. 2:45. How about that? In 40 minutes. 39 minutes now. So we're setting it up right now. I will portal you over to it, so we'll get there just fine. All right, portal is built. Just that I'm getting so good at this. One day I'm going to be a professional. All right, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again in about 40 minutes or a little less. We've got Sarah Boone hearing. We might take a look at Brian Walsh. I think that one's going to overlap our Sarah Boone, so we'll plan things out accordingly. But sounds good. I think that's it. We're going to see you guys on the other side. I'm going to continue fighting with Google and YouTube and live view and get everything sorted up for what's happening in Sarah Boone next week. Still waiting for the court to finalize all the stuff on their end as well. But it's all good. All right. Have a great lunch. We'll see you on the other side. Bye.